kuoana na matokeo rasmi ambayo yalitangazwa katika vituo vya kupiga kura.
Asante sana Enoch Sikolia. Rashid Abdalla, uko tayari na kikao chako kuweza kuendelea na mjadala huu kamili wa masuala ya kesi hii ambayo imewasilishwa mbele ya mahakama kuu. Sisi ambao tuko hapa nje tumekita kambi hapa kuhakikisha kwamba tunakuletea moja kwa moja yale ambayo yanaendelea hapa nje, lakini kwa sasa na kuregesha kwake Rashid Abdalla.
Naam, shukran sana Leila Mohamed. Wakati ukiwa unapata mawili na matatu kuhusiana na yaliyoendelea siku ya leo na mwanahabari wetu Enoch Sikolia aliyekita kambi hapa kuanzia asubuhi, pameweza kuwa na ujio wake mkuu wa sheria Githu Muigai ambaye ameweza kufika katika mahakama ya juu. Na hapa ndo nitakuja swali langu moja kwa moja kwa wewe wakili George Kithi, kwamba nafikiri mwanasheria mkuu katika kesi ya kupinga matokeo ya urais mwaka 2013 aliomba kuweza kuwa rafiki wa koti. Tumeweza kumuona ameingia hapa na baadhi ya wasaidizi wake. Je, kuna uwezekano kwamba safari hii pia akaweza kuwa rafiki wa koti?
Na maombi yatafanywa, lakini uamuzi aidha kama atakuwa rafiki wa koti ama hatakuwa utafanywa na koti. Mahakama yenyewe itafanya uamuzi huo. Lakini labda mawakili na hususan katika mahakama tunatumia sana kesi zilizopita ikawa ni mifano ya kesi ya sasa. Kwa lugha ya kikazi ama kitaaluma tukaita the precedents. Sasa huwa kama kuna ule wakati ambapo aliruhusiwa na maadili maombi ni yale kwa sasa, kuna uwezekano ama kuna urahisi zaidi kwa sababu la ile itikadi iliyopo. Waswahili wakasema kawaida ni kama sheria. Kwa hivyo kwa sababu imekuwa yamkini kawaida kwamba akifanya maombi hayo anakubalika kwa sababu mikakati ya katiba vile ilivyo, na labda kazi ambayo anatakikana aifanye katika mazingara haya ya kesi, kuna uwezekano mkubwa sana kwamba atakubaliwa. Lakini kumbuka kwamba ipo tetesi kwamba yeye anafanyia kazi serikali iliyopo sasa mamlakani, ikawa ni serikali ya mmoja ama inaongozwa na mmoja wa wale ambao wanakanusha kesi hii na walioshtakiwa pia. Kwa hivyo hiyo itakuwa ni tetesi ambayo kidogo nadhani italeta pingamizi ama atapingwa, kwa sababu rafiki wa koti akaitwa amicus kwa lugha pia ya kikazi, ni mtu ambaye akija akifanya kazi wafanya kazi kwa kusaidia koti, haegemii upande wote.
Na turudi sasa katika hichi kikao, maana hichi kikao cha matayarisho ndicho ambacho kinaangalia pia nani anaomba kuweza kuwa rafiki wa koti na nani ambaye ameomba kuweza kujumuishwa. Maana wapo tuliozungumzia jana mimi na kwa wameweza kujumuishwa, lakini kufikia leo ni kwamba vikao vinapokuwa vinaendelea, mwananchi ana imani kwamba huenda akatangaziwa muda wote kwamba labda huyu na huyu na huyu, na nikimzungumzia mgombea wa rais Michael Onaina, nikimzungumzia Daktari Kurukoni, na pia kuna tetesi kwamba kile chama cha wanasheria nchini pia wametaka kuweza kujumuishwa katika hii kesi, na chama cha Jubilee na alikadhalika. Maamuzi haya hasa anaweza kufanyika saa ngapi ili Mkenya kuweza kujua kwamba katika hii kesi sio tu mgombea wa urais wa NASA na labda mgombea wa rais yule aliyeshtakiwa kule wa Jubilee, lakini hata hawa wameweza kujumuishwa katika hii kesi?
Naam, ufahamu ni kwamba maombi haya kwanza yanawekwa katika nakala. Kwa hivyo ni maombi ambayo lazima yaandikwe, yawekwe katika nakala, yapelekwe kotini, baada ya kufailiwa ama kuwekwa kulipia yale maombi na kuyapatia wale wahusika. Tarehe ya kusikizwa ambao ni leo huwa inapewa, na baada ya maombi hayo huwa unasikizwa tetesi zako ni nini na ni kwa nini, ama umuhimu wako kulingana na mikakati ya sheria ama kanuni zilizopo. Sasa wale tuseme wote wanataka kujumuishwa ni kuhusishwa katika hii kesi, aidha kwamba mambo watakayoyatimiza yatakuwa tofauti kidogo. Kwanza kuna yule ambaye akiwa yeye anahusishwa kama mwenza wa wale ambao wako pale kotini, aidha yeye atakuwa na maombi yake maalum, alafu yule ambaye atakuwa rafiki wa koti atakuwa anasaidia koti. Kwa hivyo atakuwa upande wa koti, tuseme upande wa mahakama. Naam, lazima asikizwe wale wanaowapinga, kwa sababu kuna wale watawapinga wengine kwamba hawafai kwa katika hii kesi. Kwa mfano nimesikia tetesi kwamba upande wa NASA hautataka mkuu wa sheria kuhusishwa katika hii kesi kwa sababu atapendelea upande wa serikali, na yeye pia atakuwa na tetezi zake na maombi yake. Kwa hivyo yale malumbano ndio yatasikizwa. Baada ya watu kusikizwa, sasa koti itabidi ipeane uamuzi. Mara nyingine uamuzi unakuwa rahisi wa moja kwa moja kuambia wewe hufai, kwa sababu kuna wale moja kwa moja hawafai kuhusika katika hii kesi, labda hadhi yao ama vile wanavyojisimamisha katika jamii haiambatani na mikakati iliyowekwa, na wale ambao ni lazima kwa sababu kuna tetesi upande wote, wao koti itabidi ikae alafu itapeana ni wakati gani.
Lakini sio maamuzi yao, siku ambayo tunatarajia usiku wa leo.
No. Wengine labda ni rahisi. Kuna wale ambao watakatazwa moja kwa moja kwa leo, na wale ambao labda tetesi zao zitasikizwa alafu tutapewa tarehe ya uamuzi.
Tutaweza kupewa tarehe. Nafikiri hapa kuna kibarua ambacho kinamkodolea macho Jaji Mkuu David Maraga na naibu wake Philomena Mwilu, na pia vile kina Jackton Ojwang, Smokin Wanjala, Mohamed Ibrahim, Isaac Lenaola na Bijo Kindungu. Na hichi kitendawili ni cha idadi ya mawakili ambao wataruhusiwa pale ndani kuweza kuiendesha hii kesi, kwa sababu unakumbuka katika kesi kama hii mwaka 2015 palikuwa na hoja kwamba mawakili walikuwa wengi ndani ya mahakama, mpaka wengine wakasema kwamba labda walishindwa kupata muda bora wa kuweza kuwasilisha mashtaka yao, na wengine pia vile kupata muda wa kujitetea vizuri. Hii huwa inaamuliwaje? Ni inaamuliwa katika kikao cha matayarisho ama ni kila upande unaamua idadi ya mawakili utakaowaleta? Maana kitendawili nakumbuka kilizungumziwa sana katika kesi hapo mwaka 2013.
Naam, ni swali zuri, lakini itikadi ya kotini ni kwamba mkiwa jopo la mawakili aidha zaidi ya mmoja, hamwezi nyote kuruhusiwa kuongea, kwa sababu lazima kuwa kuna mipangilio na mikakati. Kwa hivyo huwa nyinyi wenyewe kwanza mtakaa muamue, mchague kiongozi wenu, tukamuita leading counsel. Yule kiongozi ndiye atachukua wadhifa wa kuchukua mambo muhimu kwa kueleza. Huwa mnamchagua aidha kwa sababu ya umri wake katika utendakazi, wale tunaita senior counsels, hao ndio watu tunawapa kipaumbele sana. Sisi wengine ambao tuko nyuma huwa tunawasaidia, labda kama kuna kitu hajakieleza na amekisahau, tunampa karatasi ama tunamwambia kumdokezea, lakini huwa ni msaada tunampatia. Na pili, kama tunaona kwamba mazungumzo mbele ya koti yatakuwa marefu sana, labda tunagawanya. Kuna wale ambao wanamfuata chini yake, wale pia wanachukua zoezi hilo la kuweza kuongea, lakini wanachukua mambo mengine bila kurudia vile ambavyo wameongea. Kwa hivyo mpango huu unaweza kuwa labda na mawakili 3-4 ambao wataongea, aidha kama yeye mmoja tunaona kwamba atatosha, yeye pia ataendelea na kuongea. Lakini kuna wakati mwingine kuna ile kila mtu kutaka kuonekana kuongea, kwa sababu labda ni jambo ambalo linafanyika mara moja kwa miaka 5. Sasa lile ndio likafanya wakati uliopita, kesi iliyopita, tukaona kwamba mawakili wengi sana walikuwa wanahusika. Lakini kwa sasa tunaona kwamba kuna mipangilio maalum, lakini koti pia ina nguvu za kusitisha jambo kama hilo, kusema labda mtu mmoja ama wawili peke yake ndio atakaoongea. Kwa hivyo nadhani pia katika jopo hili jambo hilo litashughulikiwa vilivyo. Na
maana ni mojawapo ya swala ambalo lazima liweze kuangaliwa ukizingatia muda uliopo na sheria zilizopo, ni kwamba kwa sasa hivi ukizingatia ile siku ambayo NASA waliweza kuleta ama mawakili wa mgombea wa rais wa NASA Raila Odinga waliweza kuwasilisha maombi yao rasmi, sasa ni kwamba kivyo vyote vile haturuhusiwi kuweza kupata tarehe moja kuhakikisha kwamba tumeweza kupata tayari suluhu na uamuzi wa mahakama hii. Na taratibu zinazoendelea, na ukiangalia kila na wanataka kuweza kujumuishwa, inamaanisha kwamba wahusika watakuwa wengi kuliko vile ambavyo watu walitarajia wakati kesi ama wakati mmoja alitangaza kwa maana kuja mahakamani. Hii nayo inampa changamoto zipi jaji mkuu kiasi cha kwamba lazima aweze kutoa haki kwa kila anayetaka kuweza kuhusishwa, ile hali muda walionao ni mchache? Nakumbuka wakati nyuma tunasema kwamba labda muda uliwanyima wale waliokuwa wameshindwa kuona kwamba ushahidi wao au kuangaliwa kikamilifu kwa 100%, na tayari uliona kwamba wameleta ushahidi wa kutosha, na waliongeza wengine pia vile kufikia hapo juzi.
Naam, nadhani muhimu na lazima tutambue ya kwamba kesi ni ya watu wawili, pande mbili tu, wale walioshtaki, wale walioshtakiwa. Iwapo uamuzi wa mahakama utagusia mtu yoyote, yani kwa mfano waseme kwamba uchaguzi huu lazima urudiwe, naam, ni nani mwingine ambaye yuko kule nje na uamuzi huo utamhitilafiana na haki zake, aidha kwa sababu ya aina ama mazingira yaliyopo, na mtu huyo hakuwa amesikizwa? Ni jukumu la mtu huyo kuja kotini ama kuja kwa mahakama kufanya maombi ya yeye kutaka kusikizwa. Aidha kama hakufanya maombi kusikizwa, bado kesi itaendelea. Kumbuka kwamba ukifanya maombi kusikizwa, wewe si mshtaki badala, wewe si mshtakiwa badala. Wewe umekuja kutafuta haki yako ilindwe, ili mradi kwamba kama uamuzi unafanywa ujulikane kwamba wewe labda utakudhuru kwa aina moja ama nyingine. Ndio sababu ya kwamba watu kama hao wanaruhusiwa, lakini si mtu yoyote yule anayefikiri kesi hii inamkera anaruhusiwa kuwa katika kesi hii. Aidha kwamba kama ungetaka ungeshtaki, lakini kwa sababu wewe hujashtaki na wewe si mshtakiwa, na kwamba wewe labda hujafanya maombi yoyote ama ufachafanya maombi lakini una umbali na kesi yenyewe, basi ikawa kwamba huwezi kuchukuliwa kwa karibu na kuruhusiwa kwa katika hii kesi. Kwa hivyo tuseme haki ambazo zinaangaliwa kwa kina zitakuwa za aliyeshtaki na aliyeshtakiwa kwanza.
Na kwa mtu yote ambaye anataka kuweza kupinga matokeo ya kura ama za uchaguzi wa mwaka 2017 tarehe 8 mwezi wa 8, ni kwamba lazima uwe na kiwango cha hela fulani katika akaunti yako, ndio baadaye uje uwasilishe ombi lako kama mimi nataka kuweza kumshtaki mtu fulani kwa kitu fulani. Je, wale ambao wanataka kuweza kujumuishwa, maana tuliona kwamba mawakili wale wa upande wa Raila Odinga walikuja wakaonesha hundi ile ya cheki yao kwamba tayari tumeweza kuweka kiwango fulani. Hao wanataka kuweza kujumuishwa, wao pia wanatakana kuweza kupitia kisheria, maana yake wana sheria, ama wao wako hapa tu kusubiri kunufaika na kama maamuzi yao yataegemea upande wao pekee?
Swali zuri. Aliyeshtaki analipa aina fulani ya pesa, ikawa kwamba ni pesa ambazo zina wakimu wale watu ambao amewashtaki, ili kwamba wakati ameshindwa kesi gharama iweze kuwafidia. Yule anayeshtakiwa pia kuna pesa ambazo hulipa. Yule ambaye anaungana na kesi kwa sababu haki zake labda hazitahifadhiwa kama hatasikizwa, yeye huwa halipi kwa sasa. Yule ambaye anakuja kotini kuungana na kesi kwa sababu ni rafiki wa koti, pia halipi lolote kwa sasa. Kwa hivyo ni kusema kwamba kuna wale ambao wako pale lakini wanaweza kurukia juu kwa juu na kunufaika bila kugaramika. Lakini pia ukumbuke kwamba kama kuna maombi watafanya mwishowe, wanaweza kugaramika. Kumbuka kwamba gharama hizi si kwa sababu eti hujaambiwa kutoka mwanzo ugaramike, uweze kugaramika mwishowe. Unaweza pia kuambiwa ulipe fidia, aidha pesa kama ushaziweka mbele ya koti ama hujaziweka, bado unaweza kushurutishwa. Zipo njia za kushurutisha kwamba uweze kulipa gharama.
Naweza kulipa gharama. Tunajua wazi kwamba katika siku ya leo kulikuwa kuna muda wa makataa kwamba kufikia saa 4 asubuhi kwa kuna muda umeweza kuwekwa kwamba ili kuweza kufahamisha mtazamaji. Una muda ule uliowekwa saa 4 kwa ni kuhakikisha kwamba nini kimefanyika kwa wale wahusika wa hii kesi ambayo inasubiri kuweza kusikizwa, labda Mungu akishajalia kuanzia siku ya Jumatatu.
Naam. Makataa yaliyowekwa ni kwa sababu watu wote wanaoshtaki, wanaotaka kuweka stakabadhi, wanataka kufanya maombi yoyote yale, ilikuwa sharti mpaka leo mwendo wa saa 4 hivi wawe washatimiza kuleta makaratasi yao, kufaili makaratasi yao yote. Hawa watakuwa wahusika, jopo la kwanza kabisa la wahusika. Alafu baada ya hapo ikawa kwamba kuna wale watakuwa katazwa kusikizwa, hao sasa watajitoa. Sasa watu watakuwa washapungua wale washiriki. Alafu baada ya hapo sasa kutakuwa na mpangilio wa atakayeanza nani, atakayejibu nani, atakayeongea mwisho pia nani. Na umuhimu wa mpangilio ni kwa sababu kuna wale ambao watakuja kuhusika katika kesi, watakokuja kuleta maombi yao, walioleta maombi yao yani washirikishwe. Sasa wao lazima stakabadhi zao ziangaliwe aidha wako upande gani. Kwa mfano bwana Kurokoti kama ataruhusiwa, nikidhani kwamba atakubaliwa. Je, yeye anataka kwamba mashtaka yaliyopo ama uchaguzi uliotangazwa kwamba Uhuru Kenyatta ndiye alikuwa mshindi ufutiliwe mbali ama usifutiliwe mbali? Sasa hapo itabidi kuwa na tathmini, je, ako upande wa walioshtaki, ako upande wa walioshtakiwa. Akiongea ataongea baada ya labda watu wanasa washaongea alafu yeye aongee, kwa sababu wakati wa kujibu itabidi bwana Uhuru Kenyatta na IBC wajibu kwa pamoja. Aidha kama upande wa Uhuru Kenyatta atachukuliwa kama yeye wapinga mashtaka haya. Kwa hivyo utaona kwamba ataletwa upande wa wale walioshtakiwa, ili mradi kwamba wakati ajibu moja kwa moja pamoja na kitita cha majibu ama jumla ya majibu ambao yatakuwa upande wa wale walioshtakiwa.
Kwa hiyo unasema kwamba kija katika masuala ya muda nani waweza kuongea kwa dakika ngapi? Maana kanajua kuna muda pia unatengwa kwamba nyinyi walioshtaki mtapewa muda fulani kujieleza hivi na walioshtakiwa muda fulani kuweza kujieleza hivi. Haya ni maafikiano ambayo yatafikiwa leo ama yashafikiwa tayari wakati tunakwenda hewani kwa sasa hivi?
Hao ni maafikiano ambayo yanafikiwa pamoja na mahakimu. Kwa hivyo utaulizwa kwa mfano wataka muda gani, na utasema labda masaa 5 ama siku moja. Wakati huo kitengwa huruhusi kupitisha wakati huo. Lakini aidha pia ukisema wakati mrefu, na tathmini ya koti ni kwamba si wakati ambao lazima upewe. Kwa mfano ikionekana kwamba maongezi yako inaweza kushurutishwa chini ya wakati fulani, utapewa wakati huo. Kwa hivyo koti ina ruhusa ya kukupa wakati. Kwa hivyo labda mkipewa tuseme siku moja nzima kwa upande wa NASA kwa mfano. Nyinyi wenyewe mna jukumu kwa hivyo ya kujigawanya. Kama mko mawakili 4, 5, mtajipanga nani atachukua muda gani na mwingine achukue muda gani, ili mradi kwamba muweze kujishurutisha ndani ya wakati huo, muweze kuwa mmeongea ipasavyo maneno yote husika ama maombi yenu yote ambayo mtakuwa mmewakilisha.
Na kama unatizama runinga yako nafikiri unaweza kuona picha tu ambazo ni ndani ya mahakama ya juu. Si tuko nje hapa ukumbini, lakini kule ndani hivi sasa ni baadhi tu ya mawakili wa pande tofauti ambao wameweza kufika pale. Nafikiri kama unaweza kuona wakili mkongwe zaidi ambaye amekuepo pia vile vile katika kesi ya mwaka 2013 Ngatia, ambaye bila shaka atakuwa anawakilisha upande ule wa Rais Uhuru Muigai Kenyatta, na pia vile vile yuko mkuu wa sheria ambaye Githu Muigai, ambaye katika kesi ya mwaka 2013 aliomba na ombi lake likakubaliwa, akawa rafiki wa koti. Na hivi sasa kama alivyozungumza hapa wakili George Kithi ni kwamba huenda ombi hilo bado lipo na tutasubiri kuweza kuangalia endapo mahakama itaweza kuangalia. Ndio baadhi tu ya masuala ambayo yanaendelea pale ndani. Nakumbuka kwamba waendesha mashtaka pia vile vile wapo kuhakikisha kwamba wale ambao wameweza kuwasilisha maombi yao ya kutaka kuweza kujumuishwa katika hii kesi pia watakuwa wanasikilizwa. Na unajua wazi kwamba kwa mujibu wa sheria ni kwamba huenda wengine wakaondolewa mapema katika kinyang'anyiro hicho kutaka kuweza kujumuishwa, labda wengine wale ambao wana uzito kwa nini wametaka kuweza kujumuishwa wakasubiri mpaka dakika ya mwisho kuweza kujumuishwa. Tayari mwanasheria mkuu nafikiri shakula magwanda yake ya kazi, ishara tosha kwamba kama alivyo kugusia tu hapo awali wakili George Kithi kwamba hapa bila shaka atakuwa anaomba ama anatoa ombi ile la kwamba ajumuishwe kama rafiki wa koti. Wapo baadhi ya mawakili miongoni mwao ni mbunge ambaye wanajumuisha upande ule wa Raila Amolo Odinga, ambaye ndiye alikuwa mgombea wa rais wa NASA, ambaye alikuwa kwanza kuweza kupinga matokeo ya urais, ambao wako pale ndani. Nafikiri kwamba hivi sasa ni juhudi ambazo zinaonyesha kwamba muda wote kuanzia sasa huenda kile kikao cha matayarisho kikawa kinaendelea tena, na yale ambayo yanajadiliwa pale ndani ni masuala ya nani ataweza kujumuishwa, ni masuala ya muda utakaotumiwa pia vile vile wa kuweza kujibu na kuweza kujieleza, na pia vile vile nani atakuwa kwanza kuzungumza, nani wa pili kuweza kuzungumza, alafu baadaye kufikia Jumatatu wa Kenya watakuwa wanajua ni timu ipi ambayo itakuwa inalumbana pale ndani mahakamani kuweza kutafuta haki. Hizo ndio baadhi ya picha za wanasheria tofauti tofauti, huko kitandawili kile cha kwamba palikuwa kuna idadi ya mawakili wengi mwaka 2013. Wakili George Kithi akisema kwamba labda huenda mahakama kwa hivi sasa kwa muda ulionao ikajaribu kuweza kuhakikisha kwamba idadi inakuwa chache mno, ndio kila upande upate kujitetea kadri ya uwezo wao. Baadaye tutakuwa tunakupeleka moja kwa moja kuweza kujua nini kinachoendelea pale ndani. Lakini ukiangalia tu msuko wa taswira iliyo pale mahakamani, na nikumbusha hoja fulani ya jinsi ambavyo haya maamuzi hufanywa. Kumbuka mwaka palikuwa na malumbano mengi na tesi kwamba hapa kuna jamii fulani, hapa kuna kabila fulani, hapa kuna kabila fulani, ambao ni moja ya changamoto ambao kweli inawakodolea macho lile jopo la watu 7 ambao linaongozwa na jaji mkuu David Maraga. Ni utaratibu upi wa mwisho ambao unaamua kwa zile kura ambazo zinaweza kutolewa? Ni uamuzi wa pamoja kwa majaji hao, na kama ni kila mtu peke yake, je, tueleze heshima ile ya uamuzi wa inaheshimiwa nani pale ndani?
Kuna aina tofauti za kupeana matokeo ambao ni kusoma yale maamuzi ya koti. Tofauti hii inategemea na itikadi ya koti yenyewe, lakini pili aidha jopo la mahakimu wanaweza kukaa chini na kukubaliana vile watakavyofanya kazi. Ya kwanza ni kwamba baada ya kusikiza kesi, mnaweza kuchukua mmoja wenu akafanya ile zoezi la kwanza ambao ni kutathmini mambo yaliyojiri kotini, tukaita summary. Na zile tunaziita facts. Kwa sababu gani? Atakayeongea atakuwa na mashtaka yake na ushahidi wake, na mwingine pia ataongea na ushahidi wake. Kwa hivyo ile ratiba ni lazima kwanza iweke. Kwa hivyo ni lazima, ama ni jukumu la mahakimu kwanza kuandika ile yote, alafu pia wakae chini, alafu kutakuwa na labda kuongea, kujaribu kujadiliana, kubadilishana mawazo.
Naam.
Alafu tatu, labda katika kubadilishana mawazo hayo, wengine watasema mimi nachukua mrengo huu, wengine nachukua mrengo huu. Baada hapo sasa kila mtu ataandika uamuzi wake, ikawa kwamba kila mtu yoelewa kesi ilivyotoka na hakuna ambaye labda amekosa lolote. Kwa hivyo mara kwanza lazima wakubali utendakazi wao utakuwa vipi. Pili pia, kama kuna mgawanyiko ama labda kila mtu anaelewa kivyake, kila mtu anaweza ruhusiwa kuandika uamuzi kivyake. Lakini katika kusoma, wakati wa kusoma kuna ile kura ile ni kama wengi wamekubali upande fulani, ndio uamuzi unaenda upande huo. Ndio sababu katika jopo la mahakimu mara nyingi unapata kwamba nambari zao si sawia. Kwa mfano huwezi kupata watu mahakimu wawili katika kesi, watatu, kwa sababu aidha kama wanatofautiana na uamuzi wao, wawili wanaweza kupeana uamuzi, aidha pia wawe watano, aidha pia wawe saba. Kwa hivyo ile una urahisi zaidi wa kufanya kwamba uamuzi uweze kulalia upande mmoja, kwa sababu labda ya maoni na uamuzi wa kila mmoja wao akisema aidha uamuzi wako umeenda upande fulani ama umeenda upande fulani, ndio ile katika sheria tukaita kwamba ni kura.
Ni kura, kwamba baada ya kuweza utaweza kuangalia upande gani ambao umeweza kupata idadi kubwa. Kama ni wanaoshtakiwa ndio watu wanaona kwamba kweli walikuwa wameweza kudhulumiwa, ndio baadaye maamuzi yanaweza kutolewa. Na mnafikiri ni utaratibu ambao tunaweza kupewa na wakili George Kithi kuhusiana na nini ambacho kinaendelea? Maana ni baadhi ya tetesi ambazo zimekuwepo wakati wa nyuma kwamba inakuwaje mpaka mwisho wa kwisha watu wakaamua kwamba kweli kesi inasimama hivi. Umeweza kusikia kwamba mwanzo ni tathmini ya kila hakimu kuweza kuifanya na kuweza kusikiliza kesi kwa umakini, alafu baadaye wanachangizana mawazo na kama anajieleza jinsi alivyoelewa, alafu mwisho wa kwisha kila mtu anasimama na upande ambao yeye anaamini kwamba ndio haki inasimama, alafu baadaye Mkenya anapata maamuzi kuhusiana na hayo. Na hayo ndio atakuwa anaendelea wakati kesi itakuwa inaanza kusikilizwa hapa ndani. Kuna mengi atakuwa anajiri baada ya muda usiokuwa mrefu. Kumbuka kwa hivi sasa kesi haijaanza kusikilizwa. Maana Mkenya anaona kwamba tayari kesi imeanza. La hasha, hichi ni kikao cha matayarisho cha kusikilizwa kwa kesi, lakini kesi yenyewe bado. Kesi inaanza kusikilizwa rasmi Mungu akishajalia siku ya Jumatatu, lakini matayarisho haya yatatoa mwelekeo ni nani na nani atakayeweza kujumuishwa katika kesi hiyo pindi itakapoanza kusikilizwa. Je, ni yupi? Wale usiandike na mate, maana wino upo hapa katika Maamuzi mwaka 2017. Mengi baada ya muda usiokuwa mrefu. Naam, karibu tena katika sehemu yetu ya pili ya maamuzi mwaka 2017 tukiwa katika nje ya mahakama ya juu ambapo kuna mengi yanaendelea hapo ndani katika matayarisho ya kuweza kusikilizwa kwa kesi ya kupinga matokeo ya urais ya tarehe 8 mwezi wa 8 ambapo mwenyekiti wa IEBC Wafula Chebukati aliweza kumtangaza Uhuru Muigai Kenyatta kama mshindi wa uchaguzi wa urais, na muda mchache baadaye upande ule ambao unawakilisha mawakili wa Raila Amolo Odinga ambaye alikuwa ni mgombea urais kwa upande wa NASA na mwenzake mgombea mwenza Kalonzo Musyoka waliweza kusema kwamba watakuja hapa katika mahakama ya juu ili kuweza kutafuta haki baada ya kwamba walikuwa wamesema kwamba watakuja mahakamani. Hivyo basi macho yote yanaangalia hapa, haki itasimama kwa upande upi? Ndio baadhi ya masuala ambayo yanaweza kuzungumziwa. Kuna mengi ya kuweza kuyazungumza na mwanasheria ambaye niko naye hapa ambaye ni wakili George Kithi. Umeweza kuona picha hapo awali kwamba ndani ya mahakama ya juu ameweza kufika tayari mwanasheria mkuu, kumeweza kufika mawakili pia vile wa upande ule wa rais na upande wa Raila Amolo Odinga, na pia vile upande wa wale ambao wanaomba kuweza kujumuishwa. Lakini kwanza kabisa tutakatuweza kwenda kwa Leila Mohamed atueleze mengi, alafu nitakupa picha za mawakili ambao miongoni mwao ni kina Ngatia, kina Pio Mumba na pia vile kina James Orengo miongoni mwa wakili wengine, kuonesha wazi kwamba tayari mkoko unaanza kualika maua. Lakini kwanza kwa Leila Mohamed.
Rashid, muda unavyozidi kuyoyoma, saa 1 kamili kuweza kutimia, baadhi ya mawakili wameshaweza kufika hapa. Nimemwona James Orengo kutoka mrengo wa NASA, Ahmed Nasir Abdullahi ambaye anawakilisha upande wa serikali vile yuko hapa akiandamana na Kithuke Kindiki pamoja na mawakili wengi. Nimemwona TJ Kajong ambaye pia ni mmoja wapo ya mawakili, lakini vile ni mbunge kutoka kwa mrengo wa NASA, na pia baadhi ya mawakili wameweza kufika hapa katika mahakama ya juu. Hapa ukitizama vizuri unaangazia kwamba hali ya usalama imeweza kuwa shwari hapa, wa Kenya wakitakiwa kupitia upande wa pale upande wa City Hall, ambapo hapo ndio mwisho kwa raia wa kawaida kuweza kufika hapa. Upande huu mwingine maafisa wa usalama wameweza kukita kambi kuhakikisha kwamba hakuna hali yoyote ambayo itaweza kufanya usalama uharibike kwa njia yoyote kufanyika, bali upande wa ODM umesisitiza kwamba wataweza kufika hapa wakati wote kuhakikisha kwamba wanaandaa maombi, ila tunaweza kupata taarifa kwamba idara ya polisi imeweza kukataza shughuli hiyo isiendelee. Kwa hivyo tunatarajia kuona kutakuwa na kitu gani baadaye katika siku hii inavyoendelea, siku hii ikiwa ni muhimu. Tunatarajia tu kuwaona majaji wakuu wakiweza kufika hapa na kesi hiyo muhimu kuweza kuanza. Wakenya kama kawaida huwa wamekusanyika hapa katika mikusanyiko ya watu kadhaa, lakini siku ya leo hakuna shughuli kama hizo zozote. Baadhi ya biashara pia kwenye barabara hii ya City Hall zimeweza kuathirika. Kuna baadhi ya mikahawa ambayo kawaida inatarajia kwamba itapata wateja, lakini kwa sababu kuna baadhi ya barabara ambazo zimeweza kufungwa hii leo hawatapata wateja wa aina yote. Polisi kuanzia sasa wanawaambia Wakenya kutopita katika utepe huu wa manjano kuhusiana na swala wa uzito wa kesi ambayo inaendelea kwa sasa. Shughuli hii muhimu kwa taifa hili, kama nilivyosema hapo awali, inaangaziwa tu sio hapa humu nchini, bali mataifa ya Afrika Mashariki na vile dunia nzima, kuona kwamba ni uamuzi upi utakaotolewa baada ya siku kadhaa ambapo kesi itaweza kusikizwa na uamuzi kutolewa na majaji 7 wa mahakama kuu, hii ikiwa ni maamuzi ya upande wa NASA kuenda kulalamikia mahakama kutokana na matokeo ambao wanahisi kwamba haikuwapendeza, na wakitaja kwamba ni vikaranga vya kompyuta, shughuli ambao huenda ikachukua muda wa wiki hii moja, ikizingatiwa kwa Septemba mosi inatarajiwa kwamba uamuzi utaweza kuwa umetolewa. Tujue ni maamuzi yapi ambayo Wakenya wanatarajia. Lakini Rashid Abdalla, kwa sasa shughuli hapa pametulia sana, sio hali ambao huwa ni kawaida hapa, ukizingatia kwamba barabara kadha zimefungwa na zitaendelea kufungwa kwa muda ambao kesi hii utakuwa unasikizwa. Wakenya wakihimizwa kutumia barabara zingine, wasiweze kuhitalifiana na shughuli inaendelea, na vile kutokamatwa na maafisa wa usalama. Rashid.
Naam, shukran sana Leila, baada ya kuweza kutueleza kinachoendelea ndani ya mahakama ya juu. Nafikiri kwamba ni matayarisho. Kumbuka hapo awali palikuwa kwa pia vile na kikao cha matayarisho cha kusikilizwa kwa kesi ya kupinga matokeo ya rais, na hivi sasa mawakili wale ambao hawakuwepo wakati ule wa mapema wameweza kufika. Tumeweza kuona mawakili kama vile kina James Orengo ameweza kufika, David Ngati alikuwepo hapo awali bado yupo, Abdullahi Nasiri pia alikuwepo pale awali bado yupo, yupo mwanasheria mkuu Githu Muigai miongoni mwa wengine, na ni kwamba muda wote shughuli ikianza ya kuweza kusikiza yale maombi ambayo yameweza kuwasilishwa na wale ambao wangependa kuweza kujumuishwa na wale ambao wameweza kuomba kuwa marafiki wa koti na utaratibu mwingine wote ambao utakuwa unajitokeza pale ndani, basi tutakuwa tunakupeleka moja kwa moja kule ndani ambako Leila Mohamed ambaye yupo ili tuweze kujua mbivu na mbichi kuhusiana na hilo. Kwa sasa hivi nafikiri kuna swala ambalo limekuwa likizungumziwa sana, na nafikiri kwamba kisheria ni muhimu tuweze kulifafanua vyema zaidi. Ni kwamba tupo na rais ambaye yuko madarakani kwa hivi sasa, na rais yule ni mmoja wa wale ambao wameweza kushtakiwa kwa sababu ya matokeo ameweza kutolewa na tume ya IEBC. Je, nchi inakuaje ile siku ya kwanza kesi ikianza kusikilizwa? Anakuwa rais wa Jamhuri ya Kenya ama anakuwa rais mteule mpaka maamuzi anapokuwa anatolewa?
Naam, Bwana Uhuru Kenyatta anashikilia nafasi mbili kwa sasa. Yeye ni amiri jeshi mkuu, rais wa nchi hii, na pia ni rais mteule, kwa sababu katika uchaguzi aligombania muhula wa pili na akateuliwa na shirika la IEBC kwamba yeye ndo rais mteule. Kwa hivyo ako kwa hii kesi kwa sababu yeye bado ni rais na yeye bado yataka katika muhula wa pili aendelee kwa rais. Kwa hivyo mtawalia kwa atakishika hatamu ya muhula ujao, yeye ataendelea kuwa rais, kwa sababu hakuna nafasi itakayoachwa ambao nchi hii haitakuwa na rais. Kwa hivyo kwa sasa tuseme yeye ndo rais, na pia akiapishwa ataendelea kuwa rais. Kama hataapishwa yule ataendelea kuwa rais mpaka yule mwingine achukue hatamu. Kumbuka kwamba kuna ule wakati ambapo mmoja anachukua kiapo cha kuwa rais. Sasa hapa ndo tamati ya kazi ya urais kwa hatamu hii.
Kwa kwamba
hakuna mwanya utakaoachwa ambao hakutakuwa na amiri jeshi mkuu wa nchi hii.
Na mtuje katika swala ambalo liliweza kujitokeza katika kikao cha mwaka 2013 kwamba ilikuwa ni vigumu sana kuweza kudhibiti, kuweka misingi katika lugha ambayo, kumbuka baadhi ya mawakili ambao wako ndani ni wanasiasa, na hao wengine ambao si wanasiasa bado wanawakilisha wanasiasa. Palikuwa na changamoto ya kuweza kuweka mpaka lugha ile ya wanasiasa ndani na lugha wanasheria ndani mahakama. Lijitokeza hilo wakili. Je, nani anapaswa kuweza kuhakikisha kwamba halifanyiki tena? Maana kwa kiasi fulani ima labda pengine litakuwa linapoteza muda ama litakuwa linakiuka na utaratibu wa kuendesha kesi katika mahakama ya juu.
Iwapo utaenda mbele za mahakama kama wakili, kuna mafunzo ambayo lazima ushapata, na hatima yake ni kwamba lazima ufuate itikadi fulani na kanuni. Semi zako ziwe za heshima, semi zako ni maneno ambayo unayachagua yakiwa yameruhusiwa katika taaluma hiyo. Kumbuka kwamba ukikosa kufuata itikadi hiyo ni makosa, na unaweza kushtakiwa na shirika ama taasisi inahusika na heshima na tabia za mawakili. Kwa hivyo kwanza, lugha yenyewe ni lugha ambayo imekubalika, yani ya heshima na ya taaluma. Na pili ni kwamba ukiwa mwanasiasa, labda kofia la wanasiasa unaliwacha nje. Ukiingia katika tajriba na labda kazi ya wakili, unafanya hiyo kwa mikakati iliyowekwa, sheria zilizowekwa. Ndio sababu tukasema ya kwamba kama wewe ni wakili utafanya kazi kama wakili, ukitoka nje utapiga siasa. Kwa hivyo tukumbuke kwamba kama ni wakili na umesema kwamba kura zimeibiwa kwa mfano, ama uchaguzi umehujumiwa, utasema semi tofauti ukiwa na umati wa watu, kwa sababu wale wakawa kwamba ni wafuasi na ni wakati wa siasa. Semi zile ni tofauti. Ukiingia ndani ya bunge, ukiingia ndani ya mahakama, bunge hawajaingia, ukiingia ndani ya mahakama ikawa kwamba sasa wewe semi zako pia ni za kiwakili, kwa sababu unaongea mbele ya mahakama. Na ukihekejeli pia, kumbuka unaweza kufungwa ndani ya mahakama kwa sababu labda umetumia semi na lugha ambayo haikubaliki. Ndio sababu utaona kwamba semi zitakuwa na mpangilio fulani na mikakati fulani na kanuni fulani, na heshima na mipaka itakuwapo na itaonekana.
Itaweza kuonekana. Tuje sasa katika utaratibu wa hii kesi. Maana yake kuna wengi ambao wameweza kuiona jinsi ilivyokuwa, na labda watu wanatarajia kwamba utakuwa na utofauti fulani kwa sababu ya muda uliopo na wale watu ambao wanataka kuhusishwa, na hatujui kama mahakama itaweza kuwajumuisha. Nini kinafanyika kuanzia Jumatatu?
Naam, sasa ikifika Jumatatu, labda jambo ambalo tunataka kuliona ambao labda tunatarajia kuliona ni kwamba wale wahusika watakuwa wameweza kuthibitishwa. Yaani kuna ambao tunawajua kwa sasa, tuna hakika watahusika ni wale walioshtaki, wale walioshtakiwa. Kuna wale mazingara ambao kuna watu wamefanya maombi hapa na pale, mashirika hapa na pale. Wale ikifika Jumatatu tutakuwa tushajua ni nani yohusika. Baada ya hapo, aidha pia tutajua wale wanahusika watashirikishwa kiupande wa kushtaki, watashirikishwa kwa upande wa wale walioshtakiwa. Kwa hivyo semi zao zitakuwa na utofauti kidogo. Baada ya hapo, labda tofauti ambayo tutakuwa nayo tena ni kwamba wakipewa muda wa kusema ni nani atachukua muda fulani ama ataongea kwa upande fulani. Sasa mtawalia ni kwamba ndio kesi itakayoanza. Tukianza kesi, watakaoanza ni akina nani, watachukua muda gani? Naam.
Na kuweza kuchukua muda gani? Na kuna hoja ambayo imeweza kuzungumziwa na tayari tumeweza kuona mahakama imeweza kutoa tahadhari kwa Wakenya wote. Na kumbuka kwamba wakati kesi inaanza kusikilizwa ndio pale ambapo kila Mkenya huwa mwepesi wa kuweza kuchambua kwa jinsi ambavyo mambo yameweza kuzungumziwa pale mahakamani. Kuna uhuru wa kutoa maoni na kuna wale ambao wanataka kuweza kusema kwamba kufikia leo mimi naona kwamba hii kesi iko hivi na hivi na hivi na hivi. Hili ni swala ambalo kwa kweli limeweza kuonekana miaka ya nyuma kwamba linahitilafiana na jinsi ambavyo, lakini mwananchi anakuambia kwamba ana uhuru wake.
Naam.
Kwa kuweza kueleza jinsi ambavyo yeye ameweza kusikiza mawakili pale ndani wa mshtakiwa na anayeshtaki, na anazungumza ima katika mitandao ya kijamii jinsi ambavyo anavyoweza kuchukulia.
Naam, Waswahili ndio wakasema kwamba usiandike na mate na wino upo. Kwamba semi za wananchi zinaruhusiwa katika katiba kwa sababu uhuru huo upo. Lakini una mipaka. Hakuna uhuru ambao hauna mipaka. Ikawa kwamba wakati unaongea katika semi hizi uongee kwa mipaka iliyowekwa. Na lazima mwananchi ajue mipaka hiyo ni gani. Mipaka hiyo ikawa ni kwamba kama wewe wataka kuongea kuhusu kesi hii, uongee kwa utaratibu wa kuheshimu kwamba uamuzi ama aidha kwamba kejeli zilizopo zitasemwa na wahusika, yani mawakili, na mashtaka yataendeshwa na mawakili. Na pia uamuzi utafanywa na koti. Kwa hivyo mahakama yenyewe ndio itapeana uamuzi. Wewe huwezi sema kwamba, kwa mfano tukisikia wanasiasa wakisema tunataka mahakimu wasome uamuzi wao, kila mtu asome atakavyo, ama kila wafanye uamuzi wao kwa mipango fulani, ikawa kwamba ni kejeli ya mahakama na hairuhusiwi. Kwa hivyo mtu anafanya makosa ikiwa yeye atapita mipaka iliyowekwa katika sheria kuzungumzia kuhusu kesi hii. Kwa hivyo huruhusiwi kukejeli uhuru wa mahakama. Uhuru wako uwepo, lakini ule wa mahakama, kwa sababu ule uhuru wa mahakama ni uhuru wa kushikilia kila mtu na ni mtawalia wa kila mtu pale.
Na mtakuja tuweza kuzungumza mengi zaidi na wakili George Kitha akituambia kwamba kweli kuanzia leo na kuendelea kwa Mkenya yote lazima mtu uweze kuwa makini sana. Unapokuwa unajieleza, una uhuru wa kuweza kuzungumza kuhusu mwelekeo wa jinsi unavyofikiria hii kesi itakavyoelekea, lakini kumbuka huru una mipaka, na mwisho wa kwisha muamuzi mkuu ni jopo la majaji 7 ambao wataweza kuamua hii kesi itakuwa inaelekea upande gani. Mengi tutaweza kuyazungumza baada ya muda usio mrefu. Kwa hapo ulipo, salia hapo hapo.
Na Maamuzi 2017 inaendelea hapa katika mahakama ya juu, siku hii ikiwa ni muhimu sana kwa historia ya taifa hili. Jaji mkuu David Maraga na kikao chake cha majaji 7 wanatarajiwa kufika hapa wakati wote kuanzia sasa na kusimamia shughuli muhimu sana, shughuli ambayo ni kionjo tu, ambapo ni mapema kabla ya kikao rasmi kuanza baadaye katika wiki ijayo. Hapa nje tunaendelea kutizama wakazi wakifika hapa, wakipita barabarani, ikizingatiwa kwamba eneo hili lote la barabara ya City Hall limeweza kufungwa. Baadhi ya mawakili bado wanaendelea kufika hapa. Muda mchache uliopita tuliweza kumuona aliyekuwa kiongozi wa wengi katika bunge la taifa Aden Duale amefika hapa na kuweza kushuhudia moja kwa moja ni yapi ambayo yataweza kusemwa hapa ndani. Pia vile vile mkuu wa sheria yuko hapa, aliweza kutuma maombi kutaka kujumuishwa katika kesi hii. Baadhi ya mawakili, James Orengo kama nilivyosema hapo awali, tumeweza kumuona aliyekuwa mbunge mteule wa seneti na pia aliweza kuwania ubunge katika eneo bunge la Lang'ata, pia yuko hapa. Baadhi ya wabunge wa ODM wako hapa vile vile ambao pia ni mawakili, wameweza kufika hapa. Mlango ule ndio wa kuingia hapa, na kwa sasa hakuna ambaye hajapata idhini maalum kupitia mahakama ya juu hawezi kuingia hapa. Hivi ndivyo shughuli ya usalama umewekwa hapa katika mahakama ya juu. Ukitazama upande wa kule ukielekea katika jumba la Kencom, unatizama kwamba kuna gari la polisi. Ukitizama hakuna shughuli yote ambayo inaendelea pale. Ukitizama kwa upande huu kuelekea katika katikati ya jiji, pia shughuli haziendelei kwa sababu maafisa wa usalama wako pale. Kuna baadhi ya maduka makuu na pia vikao, mikahawa ambayo imeathirika kutokana na biashara zao kuweza kuathirika, na vile vile raia wanaweza kupitia upande ule peke yake kuweza kuendelea na shughuli zao, na huenda wasikubaliwe kusimama kutizama jinsi shughuli zinavyoendelea. Nilivyosema hapo awali kwamba shughuli ya usalama umeweza kudumishwa kwa hali ya juu. Kamanda wa polisi Jafeth Kome akisisitiza kwamba watazingatia swala hilo la usalama hapa, kuhakikisha kwamba hakuna masuala yote ya utovu wa nidhamu. Kama nilivyosema hapo awali, chama cha ODM kimesisitiza kwamba kitaweza kutaka kufanya kikao hapa cha maombi, shughuli ambayo maafisa wa usalama wamesema haiwezekani kufanyika. Lakini hapa nje shughuli sio nyingi, huku baadhi wakiweza kufika hapa na kutizama wao wenyewe kuona ni shughuli gani ambazo zinaendelea kwa sasa. Kawaida utaweza kushuhudia kwamba kuna shughuli nyingi zinazoendelea hapa nje. Huwa kawaida kuna bunge la wananchi siku ya leo. Shughuli hiyo haiko kwa sasa. Maafisa wa usalama wamejaa hapa mjini. Shughuli hiyo ya maafisa kuweza kuwekwa hapa ilianza mapema asubuhi. Kumbuka vile vile kulikuwa na kikao maalum mapema kuanzia saa 9 hivi alasiri, ambapo mawakili wa upande zote mbili walikuwa wanatarajiwa kuwa na kikao maalum cha kuzungumzia masuala muhimu kabla ya kikao cha saa hizi saa 1. Lakini inaonekana kwamba masuala muhimu ambayo walitarajiwa kuafikiana hayakuafikiana, na huenda yakazungumziwa katika kikao cha sasa. Kumbuka leo hapo mapema ilikuwa ni muda wa Sabato, na ndio vile jaji mkuu David Maraga hakuweza kufika hapa kuendesha kikao hiki mapema. Lakini kwa vile shughuli hiyo imeweza kukamilika, sasa tunaweza kuwatarajia yeye pamoja na majaji wengine 6 wa mahakama ya juu kuweza kuendesha shughuli hii, ikiwa ni muhimu sana. Raila Odinga na kikao chake cha NASA akiongozwa na Kalonzo Musyoka pamoja na Musalia Mudavadi na Isaac Ruto pamoja na Moses Wetangula wamewakilishwa hapa na baadhi tu ya mawakili. James Orengo akitazamiwa kwamba ndi mmoja wapo ya mawakili kutoka mrengo wa NASA ambao wataweza kusimamia shughuli hii. Lakini kuna baadhi ya mawakili wengi ambao wamefika hapa. Ahmed Nasir Abdullahi, tumeweza kuona mawakili ambao wanajulikana wanajulikana, watajika, wengine ambao ndio wanachipukia tu wameweza kufika hapa. Lakini hapa hata kama wewe ni wakili, japo haujapata idhini hiyo rasmi kuhakikisha kwamba unaweza kukubaliwa kuingia hapa siku ya leo, kama ninavyosema tena, shughuli ya usalama hapa ni muhimu sana. Ukitizama upande wote ambapo ninaweza kuangalia, kuna magari ya polisi ambao wanatembea kwa miguu. Hapo awali tuliweza kuwaona polisi ambao wanatumia farasi, kuna wale ambao walikuwa na mbwa wakitembea mahali kote hapa jijini kuhakikisha kwamba shughuli ya usalama imedumishwa hapa hii leo. Lakini vile nilivyosema ni kwamba kuna baadhi ya biashara ambazo zitaathirika, ikizingatiwa kwamba amri ya kufunga barabara hii ya City Hall, mzunguko huu na barabara ambazo zinakaribia eneo hili itadumishwa hadi pale kikao hiki maalum kitaweza kukamilika. Ndio kwa maana baadhi tu ya raia wanakubaliwa kupitia upande mmoja. Kwa hivyo hata shughuli za serikali ya county zinazoongozwa na Mheshimiwa Mike Mbuvi Sonko zitaweza kufanyika kupitia upande ule mwingine wa barabara hii. Shughuli hii ikiwa ni muhimu sana, kama vile tulivyosema hapo awali, kutakuwa na baadhi ya waangalizi kutoka mataifa sio tu ya Afrika Mashariki, bali pia kutakuwa na wale kutoka bara zima la Afrika, na vile vile kimataifa. Kuna majaji, kuna wale tu raia, kuna mabalozi, wale ambao wanataka kutizamia shughuli ya jinsi kikao kama hiki kinavyoendeshwa. Kumbukeni kwamba Kenya ni taifa muhimu katika eneo hili la Afrika Mashariki, kama tulivyokuwa tukitangaza kabla ya uchaguzi mkuu. Tuliona mataifa kama vile Tanzania wakisisitiza kwamba wangependa Kenya kutekeleza shughuli hii kwa amani, vile vile na kutazamia kuzingatia kwamba matokeo haya yataweza kukubalika na kwamba taifa litaweza kuendelea mbele kutokana na shughuli hii, ikizingatiwa kwamba kuna baadhi ya mataifa ambayo yanategemea Kenya kuhusiana na kwamba Kenya iko kwenye ufuo wa bahari na ndio kiingilio cha bidhaa na raia wa kigeni katika mataifa mengine kama vile Jamhuri ya Demokrasia ya Kongo, kuna vile vile Rwanda, Burundi, Uganda pia wanatutegemea sisi. Kwa hivyo walikuwa wanaona ni muhimu sana kwa Wakenya kudumisha amani katika shughuli hii ikiwa ni wiki muhimu sana kwa taifa hili. Rais Uhuru Kenyatta tulimuona mapema wiki hii aliweza kuwasilisha stakabadhi zake hapa mahakamani. IEBC walifanya hivyo siku ya Jumatatu, waliweza kufika hapa na karatasi kadha wa kadha zikiwa ni muhimu sana kwa shughuli hii ya leo, na vile vile kabla ya kikao cha leo waliweza kuwasilisha taarifa yao kamili kuhusiana na jinsi swala hili litaweza kujibiwa, ikizingatiwa kwamba pia NASA walifika mahakamani ikiwa tu imesalia ni dakika chache muda ambao ulikuwa umewekwa kisheria kuweza kukamilika. Kwa hivyo ni malalamishi ambayo tunahisi kwamba ni muhimu sana kwa upande wa NASA. Raila Odinga mwenyewe hajaweza kufika, ila hata vile vile Rais Uhuru Kenyatta hako hapa, lakini kuna baadhi ya viongozi ambao wamefika hapa kuwasilisha mirengo tofauti ya kisiasa, na vile vile kuna mawakili ambao wanawakilisha tume ya IEBC. Hapa nje unavyotazama, nikienda tu tena kuonesha hali jinsi ilivyo hapa, unaangalia kwamba raia wanaendelea na shughuli zao upande ule wa barabara ya Wabera. Maafisa wa usalama, kuna gari ambazo zimewekwa hapa nje kuhakikisha kwamba hakuna raia ambaye hajapata idhini ya kufika hapa, kuweza kuhakikisha kwamba ni wale ambao tu wanatarajiwa kuwa hapa ndani ya mahakama ya juu kuweza kuendesha shughuli hiyo. Kama nilivyosema hapo awali, kuna baadhi ya Wakenya ambao kawaida husimama hapa nje na kufanya vikao vyao katika shughuli ya bunge la mwananchi, lakini hii leo shughuli hiyo haitoendelea, na kwa muda wa wiki moja shughuli hizo zitaweza kukatizwa. Siku hii ikiwa ni muhimu tena, David Maraga ni jaji mkuu na ndiye atakuwa akitazamiwa katika siku hizi chache zinazofuatia kuhakikisha kwamba anaweza kutoa uamuzi pamoja na majaji wenzake kuhusiana na masuala muhimu ya kesi hii ambayo itaandikwa katika vitabu vya historia vya taifa hili kuhusiana na jinsi Wakenya wanavyoendesha shughuli nzima ya uchaguzi na jinsi wanavyowasilisha malalamishi yao. NTV imekuwa hapa moja kwa moja tangu siku ambayo karatasi za NASA ziliweza kuwasilishwa, na vile vile tutaendelea kuwa hapa hadi pale uamuzi utakapotolewa, na jinsi siku kadhaa ambazo zitaendelea kufuatia zitakuwa namna gani, ikizingatiwa kwamba ni shughuli muhimu. Rais Uhuru Kenyatta akisema kwamba ataweza kukubali maamuzi ya mahakama jinsi itakavyotolewa, ikizingatiwa kwamba ikiwa itatarajiwa kwamba uchaguzi mpya utaweza kufanyika, basi amesema yuko tayari kwa shughuli ya aina hiyo au yoyote. IBC pia ikisisitiza kwamba itaweza kutii amri ya mahakama, na vile vile NASA wamesema kwamba ni muhimu, wanamtazamia Jaji David Maraga kujua atatoa uamuzi gani, kwa sababu kesi kama hii iliyowasilishwa mwaka 2013 hawakuridhishwa nayo. Siko hapa peke yangu, bali niko na mwenzangu Ken Mijungu ambaye ako na kikao chake wa kuweza kuzungumzia swala hili zima la maamuzi mwaka 2017. Ken, sijui wewe, labda mimi ni raia wa kawaida, wewe ni wakili, tueleze kwa kina ni masuala gani ambayo yanatarajiwa kuzungumziwa katika kikao ambacho kinatarajiwa kuanza muda wote kuanzia sasa.
Shukran sana Leila Mohamed, kushukuru kwa kutushikia ushukani, and welcome to the Supreme Court of Kenya. Of course, the conversation begins here tonight. In just a matter of minutes, we'll have the 7-judge bench walk into the courtroom, and of course, the status conference or the pre-trial conference will effectively begin. I have a panel here of lawyers who will be helping us get through this. But first, let me introduce them, beginning from my left. Kakai Kissinger, he's a household name in the country. We know him. He was a former Deputy Chief Registrar of the Judiciary. Thank you, Kakai, for coming. And of course, I have Duncan Okachi is coming back to help us with this conversation. Duncan, thank you for coming. He's also a lawyer. And I have Moses Kurgat, also an advocate of the High Court of Kenya. And of course, we have George Kithi. He's also joining us. He was here earlier with Rashid. Those are pictures live from the court. Oh, karibu sana, George.
Asante sana. Thank you so much.
I had introduced you because you were here the whole of the evening. George Kithi was here with Rashid earlier on. And of course, the live pictures you're seeing are from the courtroom. That is the main courtroom where the deliberations are supposed to begin in a moment. But first, I'd like to give my panel here, who will be staying with me throughout the evening, to talk about the pre-trial conference and the matters that will be emerging. And let me start with what's happening, because this is something that you have seen during the day. Let me start with security, and I'll start with Kakai. Kakai, you've seen a lot of security deployed around the judiciary. This is the headquarters and of course the Supreme Court. Was it a must to have this kind of security right now here at the judiciary?
Thanks, Ken. One is the matter before the Supreme Court is very enormous, very huge, and requires a lot of care in terms of what's happening inside the court itself and what's happening outside the court itself. As you are aware, the Supreme Court is not soundproof. And those judges will require maximum concentration in terms of listening to the lawyers and issues that are around there. So one of the things that which happened even in 2013 is you must safeguard the judiciary from outside and within, and ensure that the only people who are hanging around are people who have interest in the matter, or coming to either lawyers or pupils or whatever it is, who have interest in the matter. So you secure the place by ensuring that there's a maximum concentration. So yes, security is very important, because these are serious issues that are being discussed here.
So you find justification to the kind of security that are around here?
Yes, justification is there, and it will continue like that, if I'm not wrong, until the petition is finished.
All right, but the question, Kaka, is are they protecting the people who are inside, or they're keeping out the people who should not be coming inside?
Both. One, people who are inside, there's internal security already in those court corridors. If you walk there, you'll realize that there's police officers and securities are there.
Okay.
Two, protecting the outside of the judiciary, because you don't want people to start coming in, singing or shouting, and then the court is going on to disrupt the court. So I think that security is not in bad faith, it's in good faith, just to ensure that things move speedily. It's in the interest of Kenyans to have this matter determined as fast as possible. So let's give the judges an opportunity.
All right, let's talk to Duncan. The same question. Do you find any justification to the kind of security that is around here?
Ken, I think it's a delicate balancing act for the security officers and even the court officials. Because in one hand, you do not want to see what we saw when Raila Odinga and his troops were actually filing their petition. You saw there was a lot of disorganization, which could even have been a security threat, not only to these particular public figures, but even to the court officials themselves, such that we would want to have organization, and I believe that is the interest and purpose of this. So that only the people who have meaningful business inside that particular courtroom are allowed to be inside the courtroom. And you will notice even from the footage that you have that even the people who have been allowed to go into the courtroom have already crowded that particular courtroom. Okay. But at the end of the day, you must also balance it out with the ethos of having a trial or a hearing in public. That is actually a pillar of credibility in terms of any judicial process. And only in very certain circumstances does the court go or move into camera. So for the public, for them to know that whatever is happening is something that is open, there's nothing that is being hidden, it is important that this aspect is explained to them so that they do not perceive it as if they are being kept out. But I think that's why when the media has been allowed to air it live, maybe that gives credence to that.
All right, Moses.
Thank you.
Same question, and there are people who think this is also a form of intimidation, you know?
I don't think so. The matters taking place in the Supreme Court are very critical, and they are orderly matters. So we need to have order everywhere. We need to ensure that the people appearing in court do not feel, as Kakai said, the Supreme Court here is not soundproof. We need absolute quietness. So we don't have to have people hanging around, and most probably I think they are taking care of situations whereby you had during the day today there was an announcement that tomorrow there will be people coming to the Supreme Court to pray, and that is what I think is informing the arrangement of the security at the moment. So it is important that security is availed, so that even as here, as we are talking, we need to be sure that nobody will be able to attack us. And I believe that the orders that have been given to the security is to secure the process so that it is conducted in a civil manner.
All right. And George, you also find justification?
Absolutely, yes. What must be clear to Kenyans is that this is not ordinary. It means when we go to court all other days, we don't have this type of security. But what informed the type of arrangement or security arrangement we have now is probably because of the threat that was there initially. There has been a threat. The threat has been that if then measures that are deterrent are not put into place, that are actually visible, the people then will try and get involved, either because they are interested in the case, either because they would want to express themselves out of anger or out of whatever manner of emotions. But at the end of the day, it means there'll be commotion, there'll be disorganization. One thing that you can't do to a lawyer when he's concentrating on a case is even to pinch him. If you go ahead and pinch him, all that he was going to say disappears from his head.
So he has to refresh his thinking.
And it takes time. Even lawyers, when they start screaming at each other, they can't do that. When they do that, everything that is in their head that is supposed to be expressed disappears. It means at the end of the day, you don't only threaten those that are in court, but also the judges, because the judges need the most peaceable environment upon which this can be determined.
All right, that taken out of the way. Now you understand why you are being kept out of this. And yesterday we spoke to the CRJ and she said that you're going to be kept off until after this case. So that is taken out of the way. So let's speak about the substance of today, and I'll begin with Kakai again. What is this? What is pre-trial? What are we looking at tonight?
Now, in the Supreme Court, we have the Supreme Court Act. And if you read the Supreme Court Act and the Supreme Court rules of the 2017, they lays out a basis for pre-trial. Now, what is pre-trial? Pre-trial is once now the petitioner has filed a petition in court, and the respondents have equally filed responses, and the interested parties and the IEBC have filed their responses. All these are taken then to court. Once they are in court, the first business of the court is first of all to adopt the lawyers who are appearing or representing the parties. So in the pre-trial conference, we expect to get the following. One, all lawyers will be adopted. I am a lawyer appearing for the petitioner, I am a lawyer appearing for the respondent or IBC, they will all be adopted. Two, the pleadings that have been filed prior to this minute will now officially be adopted by the court. Because remember, before this pre-trial, any party will have withdrawn the pleadings. But now that the pre-trial has begun, you are stuck with those pleadings. So they are going to be officially adopted.
Okay.
Number three, we will have what we call in law issues. In layman's language, are questions of law that will now be agreed upon. Initially and ordinarily, these issues are supposed to be agreed upon by the lawyers and the registrar of the Supreme Court. But in most cases, and I doubt that they will agree with the registrar of the Supreme Court.
They had a meeting at 3 p.m. with the registrar.
Ah, very good.
Yes.
So if they agreed the issues with the registrar, it makes life easy for the judges. If they did not agree on those issues with the registrar, then the court will have to agree, make decision on those issues. If you look at the NASA petition, there are about 11 issues or questions of law that they have raised. But they need to pigeonhole these issues
to
into
a few that are manageable.
Most likely 3 or 4. But in 2013, we had 3 issues which were determined.
Yes.
So those are the key things that are going to be done.
Yeah,
lastly, they will have to agree on timelines. Which lawyer is talking on behalf of which party? They need to limit the number of lawyers. Remember, we have only 6 days to go. They need to limit the number of lawyers, and they'll have housekeeping rules. How many minutes per lawyer in terms of prosecuting the matter?
All right, but Duncan, look at the petition belongs to NASA, and you want to condense their issues to probably a few, probably 3 to be determined. The last election was genuine win, if the election was done in a proper way, and lastly, if the spoiled votes could be added. Why do you allow the lawyers then to agree on particular matters of issues? Forget about time first, but why must they decide on the substance, the legal issues to be determined?
Ken, even before I answer that question, I was having a cup of tea with my senior, Mr. Kurugat, and we managed to have a word with some of these lawyers, and they actually surprised us by telling us that they have already had the pretrial conference.
Okay.
So that what is coming up now is actually the canvassing of the interlocutory applications. So maybe we are yet to see, but I want to believe that what they told us is actually what will happen. But I'm glad my senior has already espoused about what happened, if actually it took place or if it will take place. But in terms of your question, it is about trying to reduce these particular issues to a manageable level, and to a level whereby you can actually regroup them, and it will be very easy for both the lawyers to canvass and the judges themselves to follow. It is a very critical issue because it saves not only on time, but it also helps the judges in terms of when they are delivering their rulings or judgments, they will actually restrict them to those particular pillars. And with those pillars, each of them may actually have the ability to either lead us back to an election, or if they fall, then maintain the status quo.
All right. And Moses, how easy is it usually for lawyers to agree on what to canvass? How easy is it? How easy is that process?
It is not very easy, Ken, I must tell you. But what happens is that matters touching on presidential petition in this country, given the time limits that are in place, the lawyers have no opportunity to disagree for the longest time. So they have to agree on issues quickly because time management is the essence of this petition. So it is not a question of them agreeing or disagreeing on issues, because when they disagree, then the court will frame the issues for them and then go for determination. So it is easy to manage time and also to allow the judges room to think through the pleadings in order to make decisions as quickly as possible. So given the period that is left now before the ruling is delivered, we've got only less than 7 days to go.
It's actually 4 days,
4 days,
I think.
yes.
4
So
days, yes.
you can see the amount of work. That is why lawyers are requested to compress whatever they have so that the judges can decipher, because they have the opportunity of reading the pleadings as filed plus all the documents. I know for sure that the judges right now sitting in the Supreme Court will have read all the pleadings, will have perused through all the documents, and they are ready now to hear the matter for purposes of only hearing the submissions of the parties. So a pre-trial conference, if it has taken place as we were told earlier on, then right now what is going to happen is the issues of dealing with what we call interlocutory applications which are applications that are coming in. That is for parties interested in the petition.
Parties,
yes, people, the friends of the court, like the Attorney General, like I've seen him there, is in court, and also other presidential candidates who are supporting either the petition or opposing the petition.
All right. George, talk to us about the agreement that they are supposed to agree on. For example, who to speak first and what durations are given. Why is this important? Why must they agree on those things?
You know, when you give a lawyer an opportunity to talk, there's something called talking in eternity. That's possible. Because they're trained in the art of talking and writing. And they convert words into, into paragraphs and so on and so forth. You will realize that, for instance, if you're given a document that is 35 pages, it can be reduced easily into 7 pages if it's properly organized. So to organize lawyers, in a sense, you need to limit them. The reason why they're limited is because then time is what then is measured against justice. You know, adequate time is not the time that you must be given. It's enough time for you to express yourself.
In whose view?
So the right
in whose view?
You will probably be asked the first question as to how much time you plead with the court to be given.
To give you.
You may say 3 days, and I will personally here ask for 3 days if I was leading. But you know what will happen? You can't be given the 3 days because there's no time for 3 days anyway. Mm-hmm. What you'll be given is probably 3 hours. Because you need to condense everything first in your pleadings. You have an opportunity to have written down the summary of what you're going to say in the submissions. That's why they're called skeleton submissions. All you need to do is highlight a few issues. For instance, if you have cases you've taken over from England or wherever you brought them, you need to explain the background and the connection between what you're saying and the case before the court. Just bring that connection, and by it becomes very easy. So realize that ultimately, if you reduce the times to 2 hours, they'll still speak for those 2 hours. By the way, even if you give 45 minutes for each of them, they'll still comply, and you'll still have the same result. So then, by practice and experience, you realize that you need then to condense the lawyers' times. But again, the right to be heard is because others must be heard. If you're given all the time with limited time, the others won't have the time. So then that right will be denied to others, whereas be afforded to others. That's why it's important to reduce the times and restrict people in their talking.
All right, the split images on your screen are from the main court, inside the court. We already know by now that there's a lot of people, 200 media personalities accredited to cover this event. We have more than 34 lawyers who are trying, or who will be representing the interests of their clients in this case. So what the judiciary has done is to have the main court building, and then they have another one availed for the extra lawyers who will not be able to get to the main courtroom, which is what you're looking at right now on your screen. This will be mainly for the lawyers who will be directly participating. But we have so many supporting funds, for example, who still need to participate, but they have been given another room where they'll be sitting comfortably. And this is also the day that we will finally know about the bar, who exactly will be on record for these different institutions or different individuals who like to be participating in this case. We already know also that 4 individuals, including 2 presidential candidates, have already expressed interest to participate in this. We know that there are several others who want to be friends of the court also, and this is also the day that we will know who will be allowed to participate or not. But let's talk about the substance of this, and from the top of my mind, and I'll begin with Duncan on this. Duncan, from the top of your mind, what issues are likely, and I know the petitions have fairly been out now, what issues are likely to be brought to court today as part of the petition or in their pleadings?
There's a very sensitive application which I've been told has already been filed by NASA, and actually it is in respect to the responses filed by both the IEBC and the ruling party, Jubilee Party. The Constitution says that responses should be filed within 4 days of service. The petition was served on the 20th. IEBC and most of the Jubilee replying affidavits were filed on the 25th. So there is an application by NASA to strike out those particular pleadings and annexures, which is very dangerous because actually it will leave IEBC out in the cold, and even Jubilee. The reasoning behind the NASA's application is that 2013 ruling by the Supreme Court itself in terms of time. And they were very strict, and they actually threw out the 900-page affidavit by Raila Odinga. So it is for us to see whether they will maintain the same standards and throw them out, which substantially will leave the respondents in the cold. That's a major issue.
But we know that the rules were revised, and that's the reason why by yesterday at around 1 p.m. they were allowed to file, let me call them supplementary pleadings yesterday. I saw them here.
Yes, the rules were revised, but remember, rules are subservient to the Constitution itself and even to the Elections Act. So that is actually what guides this particular process. And that's why I'm saying we are yet to see in terms of the ruling and actually the jurisprudence that will come out of there in terms of the application itself.
Then the question will be, Kakai, if that's possible, what Okachi is speaking about, what would have happened if the petition was filed late? Would they have allowed it?
Now,
thinking about what Okachi is saying at the back of your mind.
At what he's talking about and refreshing and recollecting what happened in 2013, circumstances were completely different. Because in 2013, the 800 pages were dismissed, if I do recall very well, were dismissed because the then rules of 2012 petition rules were extraordinarily hard on technicalities.
Okay.
But now, when you look at the spirit of the Constitution and litigation nowadays is to move away from technicalities and completely lift the issue of technicalities so that technicalities should not be a reason why one's petition or one's pleadings that have been filed should be removed. Now, when you look at the 2017 rules, it's also running away from technicalities. So it's very unlikely that the application of NASA will see the light of the day. It's extremely unlikely. They will be able to justify why they filed those things out of time. And remember that the Supreme Court is not bound by the decision they made in 2013.
Yes.
Yes.
Okay. But that doesn't answer my question of looking at this circumstance. What will change? What is different? If at all, part of the timeline that we were given running from the 18th until today, strictly adhered to, what will change?
No, nothing will change. Nothing will change at all. And remember,
so if they filed out, what will happen? Because that's what I want to address. If they filed out of time, if they didn't beat some deadlines. For example, yesterday at 7 p.m.
You know what is there is that they'll be given an opportunity to respond. Because these are interlocutory applications. They'll be given an opportunity to respond. Explain why you filed out of time. Okay. They'll always have a reason why they filed this thing out of time. So if it's more justifiable, then things remain as they are.
Okay. All right. As the judges walk in, I'd like to give George and Kurgat also an opportunity just briefly to weigh in on that, because I see the registrar is already there as they settle on technicality.
Yeah, thank you very much, Ken. I think the era for technicalities is behind us in the practice of our courts. It is not going to be possible for any technicalities to be allowed to prevail. And any applications, I do not know. I'm not privy to any of the what my learned friend Mr. Okacha said. I do not know what application has been filed, but I think with the time as we sit here, we'll get to know. And then, of course, we'll be in a better position to make informed comments.
All right, George, briefly as they settle.
Well, first as they settle, I see that they've changed their attire.
The back to red. The red.
The back to red. Yeah. Well, the other one, we didn't want to say loudly, but it was ugly, frankly speaking. But probably they've gone to back to this is what we are used to in court. Yeah. But what I want to see this time.
I think the registrar is speaking. I'll begin with you. Let's just listen in, and then we'll begin with you.
No problem.
All right.
Petition number 1 of 2017, Raila Amolo Odinga and another versus the IBC and 2 others. You are welcome, and please make sure your phones are off. Thank you and welcome, Mr. CJ.
Thank you. I can see several councils standing. There are no seats. No, but they should have provided for those seats.
Because they are very young advocates who we are urging to do what the profession requires. So the senior advocate is going to read it.
Esther, can somebody get some loose seats at least so that we have everybody seated? Sorry for that, Mr. Mwenesi, Mr. Gatia, as they bring the seats.
Thank you.
I want to take this opportunity to welcome you all to the Supreme Court. I want to start by recognizing the presence of observers. We have in the gallery judges from other jurisdictions who have come to observe what we do. Somebody was bringing me the names of the judges who are there. Do you have them? We'll get them. If it will not be discourteous, my lords, if I could ask you to just stand up and wave the judges from other jurisdictions who are with us here. Thank you very much. Welcome to Kenya and welcome to the Supreme Court. I also want to welcome all counsel. I think it would be in order if we have the lead counsel for each party to introduce their teams so that we know who is in, and then we proceed. You will forgive us, the courtroom is small, that's why we are so squeezed, but arrangements are being made so that loose chairs can be brought for other people to be able to sit. While those chairs are being brought, may I request senior counsel for each party to introduce their team so that we know who is who. Can we start with the, yes?
Yes, my lords and my lady. I don't know whether to say good evening or good night. But we have the privilege and pleasure to appear before your lordships and my ladies. The appearances for the petitioners, there are two petitioners. Myself, although I appear together with my senior Feroz Norji, senior counsel, but I'm the lead counsel. James Orengo, together with Feroz Norji, senior counsel. Senior counsel and Attorney General Emeritus Amos Wako is not robbed for purposes of today, but will be, in subsequent proceedings, be appropriately robbed. Senior counsel Okongo Omugeni is in court. Paul Otiende Amolo, Dr. Mutaha Kangu, Honorable T.J. Kajuang, Mr. Paul Mwangi, Professor Ben Sihanya, Honorable Peter Opondo Kaluma, Madam Julie Soweto Aulo, Mr. Norman Magaya, learned friend Celestine Opio, learned friend Salma Achieng, learned friend Judy Olo, learned friend Willis Otieno, learned friends Anthony Oloch, Honorable Daniel Manzo, learned friend Ojeng Oginga, and last but not least, our advocate on record, Mr. Jackson Awele. That is the entire team for the petitioners.
Thank you. Thank you very much. Thank you very much, Honorable Orengo, for the...
My Lord, I am here for the first respondent, that is the Independent Electoral and Boundaries Commission.
Please speak to the microphone, always.
For the first respondent, I appear with Senior Counsel Lucy Kabuni, Cyprian Wekesa, Eric Wumbo, George Murugu, Mahat Samane, and Sisulu. For the second respondent, that is the chairman of IEBC, Mr. Kamau Karori, appears with Professor PLO Lumumba, Issa Mansour, and Peter Wanyama. We are following the order that Your Lordship said we follow. We had actually asked the Attorney General, who is the titular head of the bar, to introduce all of us, but you follow the order that Your Lordship indicated. Thank you.
Sorry for that omission, but
It's not quite an omission. He is not a party to this proceedings.
Whenever the Attorney General is present in court, he comes with his capacity as the titular head of the bar.
We are not sure.
Which is set out in statute. My Lord will be guided by you.
Very well, very well. Okay, let's go for the third respondent.
I hope the mic is on. Good. May it please you, my Lord Chief Justice, Your Ladyship, my Lords. For the third respondent, we have a team as follows. My name is Ngatia Frederick. I appear together with Senior Counsel Ahmed Nat Seal and my learned friend, my learned colleague, Ken Ogeto. Lean team of 3.
Thank you. Thank you very much.
My Lord, may I, with your permission, as I believe this is a record of the proceedings in general, indicate that I am present with Ithu Muigai, Attorney General, intended amicus, and I am assisted by Charles Mutinda, State Counsel.
Very well.
With your permission, Lord Chief Justice, my Lady Deputy Chief Justice, Judges of the Supreme Court, my name is Stephen Mwenesi. I appear in this matter for the Law Society of Kenya, an intended amicus, present today with my learned friend, Mr. Kiari Mungai. We will be joined by Mr. Omwanza Ombati, should we be allowed to continue. Thank you and good evening.
Thank you.
May it please you, Your Lordship, the Chief Justice, my lords, my ladies.
Please raise your voice if you...
May it please you, Your Lordship, the Chief Justice, my lords and my ladies. Harrison Kinyanjui, I appear with Kwesiga Malinzi for an interested party amicus upon your order, Professor Michael Wainaina. He was an independent candidate in the concluded election and will be presenting our position why he should be enjoined. Thank you, my lords, my ladies.
Thank you.
May it please the court, my lords, my ladies. My name is Charles Kanjama, and I appear as a proposed intended amicus for self.
Thank you.
May it please the court. My name is Elias Mutuma. I appear alongside with my learned friend, Ignatius Mohatia, for the first intended interested party, Dr. Ekuru Aukot. Thank you.
Thank you.
My Lord, may it please you. My name is Kamodo Jenga. I appear for the ICT Association of Kenya as an intended amicus curiae.
Thank you.
May it please the court. My name is Isaac Aluochier, intended second interested party.
Thank you. Very well. Thank you for those introductions. First and foremost, I want to thank you all for the indulgence. I want to start with my colleagues who were kind enough to oblige me so that we are able to start at this time. And for you, counsel, to come in, I don't want to take this for granted. I want to thank you most sincerely for that accommodation so that we are able to start these proceedings at this time. As you know, because of the limited time, we may, on some other days, have to sit late, and I want to seek for the indulgence of all of us. Now, ladies and gentlemen, everybody knows that this is not an ordinary piece of litigation. It's not an ordinary piece of litigation. We all are aware of the time constraints, and unless we cooperate, we will have problems. So I want to seek your indulgence. I want to seek your indulgence, all of you, that when we start, first and foremost, let us have respect for each other. Absolute respect for each other. Let us conduct these proceedings soberly. I know the emotions of your clients. I don't want counsel to descend the arena of the clients, so that we are able to conduct the court business the way it is supposed to be conducted, with decorum, and as I've said, with respect for each other. And then we'll move on fairly smoothly. That's why I said, please don't bring in any emotions from your clients. We are not here in a campaign forum, so let us restrict ourselves and deal with the matters that are before us. This evening, we have several applications. We have applications for people who want to be joined as amicus. Who are the parties who want to be joined as amicus? Once again, just the Honorable Attorney General, the Honorable, the LSK, Mr. Kanjama, and who else? Mr. Njenga.
ICT Association of Kenya.
Yes. We will deal with those applications and give rulings tomorrow. Now, we have applications by parties who want to be joined as interested parties. Mr. Kinyanjui, your client, Mr.
Elias
Mutuma, for Mr. Aukot, and yes. We will also deal with those applications and give our rulings tomorrow. This evening, we want, before we go to the pre-trial conference, there are two applications. Two applications seeking to strike out certain pleadings. Who are the applicants in these applications?
My Lord, may I, with your permission, for the avoidance of doubt, ensure that we have understood you. When you say, my Lord, that you will deal with the amicus application, does my Lord mean you do not wish us to make oral submissions? Because my understanding of the rules is that you could do, it is within your discretions, my Lord, to make that ruling without necessarily hearing the parties. And I want to be sure that I've understood you.
Very well. The applications have said we are going to give rulings tomorrow. We will deal with them on the basis of the pleadings and the replies.
I'm most obliged. I'm most obliged.
So those ones, we are not going to allow any oral submissions.
Most obliged.
The ones we want to allow fairly short oral submissions are the ones seeking to strike out pleadings. Who are those who are seeking to strike out pleadings?
My Lord Chief Justice, my Lords, the third respondent filed a motion seeking to strike out certain pleadings filed by the petitioner.
Yes.
The application has been responded to. We are ready and able to make very brief submissions in respect to that motion.
Very well. Which is the other application?
The opposite, an application by the petitioner, you say.
There's who is the applicant?
Yeah, we also have an application to strike out the
Yes.
responses from the respondents. That application, on our behalf, will be prosecuted by our learned junior, Mr. Wele.
Yes.
Yeah.
We have looked at those applications, Mr. Ngatia, Mr. Orengo, and Mr. Awele. The main ground is that those pleadings were filed late. Am I correct?
Yes.
Huh?
Served late, my lord.
Served late. Whose was filed late? It is only service. It's only service.
My Lord, the application by the petitioner to strike out the submissions by the first and the second respondents, which submissions were filed on time, the only ground on which they are seeking to strike out, excuse me, those submissions.
Is the microphone on?
Is on the basis that our submissions were served out of time. And I think you will notice from our response that our submissions were filed at 11 p.m. at night. We proceeded to the offices shown in the records here as a place for service of the petitioner, and we found their offices closed. We were there before midnight.
Very well.
So
Don't argue the application yet.
No, I'm
Yes.
just pointing out
Yes.
that is the nature
Yes.
of the matter.
Yes.
We filed in time.
Yes.
We sought to serve on time,
Yes.
but the offices were closed.
Yes. Now, our question is this, Council. You can't consent to this so that we are able to move rather than spend time on arguing whether or not an application or a pleading that has been served out of time should be struck out. We go and make rulings.
I wish I could make it easy for the court, but on our part, it's not possible because certain pleadings have never been served to date. They were not served in time. Even if we were requested to take them 2 or 3 days thereafter, we would have done so. But until to date, they have never been served.
Which ones are those?
They are on the face of the motion.
Yes.
We have tabulated each one of them. There are 2 sets of pleadings that were not served, then pleadings that were served on a Sunday afternoon without leave of court, and again, those have never been served on us. So it's not possible for us to consent on those things. If a request had been made by counsel, I would have been the first one to say, yes, let's extend time to counsel.
Yeah, but the request is now coming from court.
My Lord, our position is that we'd rather let every pleadings filed be allowed. That is because going through our brief is not quite correct that they filed in time and served on time. And we got evidence to show that that was not done. But because of the nature of this matter, we would rather everybody is fully heard, the responses are fully taken into account, there is nothing to fear, it's all about what happened and the law.
My Lords, I'd like to request you to take the speech made by the Honorable James Orengo to apply it to my own application.
But my Lord, when he's admitted, I'll have no problem.
My Lords, Your Ladyship, we have one difficulty in going along with the suggestion made by my Lord the Chief Justice. Because the application we have made, that is the first and the second respondent, to strike out 3 volumes filed by the petitioner. Those 3 volumes relate to evidence, additional evidence, filed outside the constitutional limit of 14 days. So that is a difficulty that we have.
Very well. Very well. That being the case, Council, we want to start. We will give you 10 minutes each. 10 minutes each, strictly 10 minutes. And as I said, please let us have a cooperation. We have your applications. We will look at them. Let's see who starts. Who is seeking to strike out the pleadings by the petitioner?
We are, and our application will be argued by Issa Mansour. Well, we've been told to address the court. Yeah.
Yes, Mansour, you have had 10 minutes.
Yes, my Lord.
And please stick to that.
Yes, my Lord. We filed a notice of motion application dated the 25th of August 2017. We've served it on all the parties. My Lord, on the face of it, we seek to strike out the following documents. The affidavit of Dr. Edgar Ouko Otumba, sworn on the 25th of August 2017. The affidavit of Norman Magaya, in support of the petition sworn on the 23rd of August 2017 and filed on the 25th of August 2017. There's a supporting affidavit of Omar Yusuf Mohammed, sworn on the 24th of August 2017 and filed on 25th of August 2017. And lastly, a supplementary affidavit of Ogla Karani, sworn on the 25th of August 2017 and filed on the same date. The reasons we seek to strike out this affidavits is that the petitioners filed a petition on the 18th of August 2017 within the constitutional time prescribed of 14 days. Within the time prescribed for filing the petition, pursuant to Rule 6 of the Supreme Court Presidential Election Petition Rules 2017. But the petition is defined under the rules to include an affidavit required to support the petition. And Rule 10 provides that the petitioner shall, within 2 days of filing the petition, serve the petition upon the respondent. Now, in terms of these affidavits, we had already first responded to the petition, having been served on the 20th of August with the petition and the original supporting affidavits. But these extra affidavits were filed outside the time prescribed for filing the petition, together with the supporting evidence in the affidavits. And more importantly, there is new issues that we have had no time to respond to. There is new causes of action, and they contain additional evidence that change the nature and the character of the petition, and it will prejudice both the first respondent's ability to respond to this affidavit as the pleadings have closed, as well as the second respondent, the chairman of the IEBC.
When did you say you were served?
With regard to the first affidavit of Dr. Edgar Ouko Otumba, it was served on the 25th of August 2017. Norman Magaya, it was also filed and served on the 25th of August 2017. Omar Yusuf on the 25th of August 2017. And lastly, the one of Ogla Karani on the 25th of August 2017.
So they were all served on 25th?
On the 25th, yes. They were sworn on different dates.
Yes.
But served on the same date.
Okay.
So, my Lord, for those reasons, as the first and second respondents will be prejudiced, they cannot respond to these affidavits in terms of replying by affidavits sworn on behalf of the first and second respondents. And more crucially, we had already filed our submissions and response to the petition within the timelines stipulated under the rules. And Lord, because they go towards prejudicing our client's right to a fair hearing, and no reasons have been advanced why they could not be filed within the stipulated time, Lord, we urge you to strike out these affidavits. They have been filed out of time, and the petition should proceed on the basis of the evidence that was tendered within the constitutional and statutory time prescribed by law. That's all, unless you have a question.
Thank you very much, Mr. Mansour. Who is next?
My Lord, Mr. Otiende will respond on our behalf.
Sorry?
Mr. Otiende Molo will respond on our behalf to that application.
Yes.
If it may please, my Lord, 3 quick responses. That application, my Lord, is based on a misapprehension. All the 4 affidavits spoken to are not filed in support of the petition, but they are filed in support of the application by the petitioner, which my lords are yet to hear. That is the application seeking various interlocutory reliefs. My lords will look at page 10 of that application, and we'll see that all those affidavits mentioned by Raila Odinga, Omar Yusuf, Dr. Edgar Otumba, Nyangasi Oduo, Norman Magaya, are in support of the application, not the petition yet. Second, my Lord, When we prosecute that application, as is clear in prayer number 7, we shall seek leave that other than being filed in support of that application, that this court be pleased to grant leave that those very documents also be filed in support of the petition. That has not come. Therefore, the objection is misplaced. Secondly, my Lord, the reason we take the position that Senior Counsel Rengo indicated is that if we start looking at who filed what document late and served late, almost all the pleadings filed and served by the respondents will be struck off. Either because, one, my Lord, that the very application to strike out was itself served out of your direction. It was served after 1 p.m. when the direction required that all interlocutory applications be filed before. That all the responses, as indicated by Senior Counsel Mwite, were not served within the time prescribed. The question of whether which office was closed will invite us to cross-examine Senior Counsel Mwite as to whether he appeared in that office or not. So we were taking the easier option of saying, let all these documents be admitted, and we go to the substratum of the matter. And lastly, my Lord, that our overall position is to go to the substratum and not to invite this court to fall into the trap that is being set of going on technicalities rather than substantive justice. That is our response.
Thank you very much, Mr. Mamolo.
My Lords, we have two applications before you, both by notice of motion. The first one, court stamped 25th August this year. As regards that application, 25th August this year, there are two very, very unfortunate incidences or factors. In respect to the first set of documents, while as we were served with a petition on Sunday was 20th August, perhaps I could let...
Your time is still running.
Oh, we were served on 20th August at 5:15, while being served, and I hope this is common ground, it must be common ground, certain documents were not served. And those documents are tabulated in prayer number 1 in the notice of motion. Those documents have never been served to date. So, my Lords, I would have taken the olive branch if they were served on Monday or Tuesday. The position is they have never been served to date. And those are the documents in prayer number 1 in our notice of motion. In the same notice of motion is an incident that took place. On Sunday 20th, petitioner came to your registry at 1 p.m., procured a clerk to accept documents tabulated in prayer number 2, and they were...
Mr. Ngata, by procured a clerk.
No, cost. I think cost. Yes.
Procuring.
Will be that scientific, my Lord, henceforth. Caused a clerk to stamp the documents 18th. And I'm saying this not as something I am aware of. I became aware of it from the letter by your registrar. There is a letter from your registrar to that effect, that those documents were backdated 18th instead of the date that they were presented. Once again, my Lords, I'll be the first to have indulged counsel if a request was made for an extension of 1 or 2 or even 3 days. But to cause a document to be backdated, coming from my legal training, is not the correct way. We should be priests at the altar of justice. We should be doing that which is correct instead of backdating documents. On the basis that those documents were backdated, my lords, we would urge that they be expunged from the court record. That's the first notice of motion. Second notice of motion, court termed 26th August. After the close of pleadings, 5 new affidavits were filed by the petitioner, 5 new affidavits, raising new evidence. That evidence, my lords, under the rules and the protocol you have established, we have no time to respond to it. And these are 5 affidavits. So once again, my lords, we find ourselves at a very awkward position that new evidence has been tendered. It should have been tendered with the petition. Our time for response has expired, and without any leave and without even any indication that leave would be sought, with a corresponding increase for time to be given to us to respond, a petitioner has again caused the registry to accept pleadings or affidavits which would be very prejudicial to our client. So, my lords, you will see the difficulty that I have, a difficulty which is a real difficulty. If these affidavits remain on record, I do not have the opportunity to cause my client to respond to them. There will be a real prejudice, not apprehended prejudice, but a real prejudice. Equally, if the first set of documents are again accepted to remain on record, there is a real prejudice to the third respondent. My lords, we have filed submissions in respect to both applications. We would urge you to allow them as requested.
My Lord, with your permission, again I'll respond to my learned friend's application. My Lord, the application being prosecuted before you was filed yesterday, itself after 1 p.m. If we were to go by my learned friend's implorations on time, the application itself ought not to be had, given your directions that all interlocutory applications were to be filed before 1 p.m. That is the first point.
What time did you say it was filed?
It was filed after 1 p.m. and served at 4:50 p.m. My Lord, the second point is that my learned friend's application, unfortunately, again, is a misapprehension and a misconception. My Lord, Dr. Nyangasi Oduo has 2 affidavits before you. There's his initial affidavit and a further affidavit, all filed and served in time. My Lords will notice in the schedule prepared by your registry that the first affidavit appears as number 4. The further affidavit appears as number 14. Both were filed and served on the respondents, and that they have not disputed. The misconception, my Lord, comes in the annexures. The first affidavit has annexures DNO 1 up to 7, and they are marked in volumes. The second affidavit has 2 sets of annexures, DNO 1A to Z. That is the annexures to the second affidavit. My learned senior obviously looked at the annexures to the first affidavit and only saw DNO 1 to 7. But the ones that he attacks in paragraph 1C is not only one, my lord. It is DNO 1, 2A to 2Z. And they're in volumes which each of my lords, I'm sure, have. They're marked from number 1 to 64. The second set is in the further affidavit, which my learned friends attacked at part D and E. It is marked in the further affidavit as DNO 2A. The only indulgence that we were going to seek, my lord, in that respect, is that the typographical area for DNO 2A was to read 3A only. But the document and the volumes were filed and served in time, and they support the further affidavit.
So you say the only thing you are seeking is what?
My lord, to correct the typographical error in paragraph 5 of Dr. Nyangasi's further affidavit, where it refers to the second annexure as DNO 2A. It should be DNO 3A to U. There are 19 volumes, all of which were filed and served in time. My lord, lastly, the documents that we have referred to were all filed, served in time, and the evidence for that, my lord, is not even for us to provide. The evidence is that each of my lords will find that the documents referred to were with you. It is inconceivable, my lord, that we could have sneaked into all your chambers and sneaked in documents as suggested by my learned senior. Thank you, my lord.
Thank you. Thank you very much.
My lord, I believe there was our own application to strike out which our learned friend Mr. Wele would prosecute.
Thank you, Your Lordships. My Lord, ours is a notice of motion application dated 26th of August 2017, principally seeking the first two prayers on the face of that application. The first prayer being, my Lord, the striking out of all the documents that were filed by the first and second respondents on the petitioners in response to the petition, and they are set out on the face of the application. And the second prayer being for the striking out of all the documents that, I beg your pardon, my Lord, the first prayer being for the striking out of all the documents that were served in response to the petition by the third respondent, and the second prayer being for the striking out of all the documents that were filed by the first and second respondents on the petitioners in response to the petition. My Lord, the application is premised on Rule 17 for the avoidance of doubt of the Supreme Court presidential election petition rules that permit any party wishing to file an interlocutory application to do so 1 day after close of pleadings. And that day was the 26th of August 2017. The substance of the application, my Lord, is premised on Rule 11.1 of the presidential election petition rules, which basically require any person wishing to file any response to a petition to do so within 4 days of the filing of the petition. My Lords, the petition was filed on the 18th of August 2017, and the same was served on the respondents on the 20th of August 2017, well within the time prescribed by the rules. My Lord, we were, however, served with the responses, all the responses that have been set out on the face of the application, on the 25th of August 2017, well outside the time stipulated by the rules for service of answers to the petition and all affidavits in support of the same. My Lord, the answer that my learned senior counsel Mwite attempted to give for the late filing does not sufficiently address the reason why the same was filed out of time, because even though our office may have been closed at 11 p.m., my Lord, the rules required the respondents to file and serve within 4 days. These are rules that the respondents were aware of. It was up to the respondents to make the necessary arrangements to make sure that as at the time that they file their documents, they should be able to serve the same on the petitioners. But even so, my Lord, the following day when the documents were ultimately served on us, they were served, the earliest documents that were served on us were for the third respondent, and they were served on us at 3 p.m. in the afternoon, and followed by the first and second respondent served at 3:50 p.m. in the afternoon. No explanation has been given, my lords, for why those documents were served at that time, when it was well within their knowledge that the very nature of this application, and of course the voluminous nature of the documents that were eventually served on us, as you can see on the face of the application, would require the respondents, or rather the petitioners, to discern those documents and to prepare responses by way of rejoinder, as they are entitled to, as we are entitled to within the rules, within time. The same was served on us late. Pleadings have now closed, my lords, and we are obviously, as Mr. Ngatia has stated, unable to get the petitioners to sufficiently appreciate the issues raised in the answer to the petition and the affidavits, and to instruct us on appropriate rejoinders for the same. To that extent, my lords, the petitioners are equally prejudiced in the sense that they will not be able to exercise a right that is conferred by the rules to file a rejoinder. And of course, this then goes to the root of the right to fair hearing. As we speak, my lord, we have not been able to prepare any rejoinder to the documents that were served on us late. And in fact, as at this morning, when we were filing our list and bundle of authorities, I was in the registry myself, and one of the documents that was also served late, and which is not in the application, was being served at the time. And that is the written submissions by the respondents. So, my lord, for those reasons, we pray that the application be allowed with cause. Thank you, my lord.
My lords, on behalf of the first respondent, the application by the petitioner is opposed. And my lords, the first respondent has opposed that application by way of an affidavit sworn and filed in this honorable court today by Mr. Moses Kipkoge. And I will be brief in my response, my lords. The petitioner acknowledges that the responses were indeed filed in time. And my lord, for the purposes of the response, it is important for me to point out that those responses were filed in the registry of this honorable court at 11:24 p.m. My lord, that is important because this court had gone out of its way to ensure that its registry was open and its staff were available to receive the responses on the last day that they were due. Your lordships will note that in the replying affidavit of Mr. Kipkoge, at paragraph 5, he deponds to the fact that at 20 minutes to midnight, 15 minutes after the documents were received in this registry, he went to the chambers of the advocates on record for the petitioner and they were closed. There was nobody to accept service. My lords, on behalf of the first respondent, I submit that in the same manner that the court had gone out of its way to keep its registry open, it was incumbent on the petitioner in this matter, or counsel on record for the petitioner, to ensure that there was somebody in their chambers to receive service of documents. There was nobody. And my lord, it has come from counsel for the petitioner that the documents were served on them the very next possible day. Having filed the responses in time, my lords, there was absolutely nothing the first and second respondents could have done to cause or to effect lawful service on the night of the 24th of August this year. As chambers, my lord, for counsel for the petitioner was closed. My lord, for those reasons, I do urge you to dismiss the application before you. The responses are important and they were filed on time. They were served on the 25th through no fault of the first and second respondent. And the first and second respondent should therefore not be prejudiced for that.
Thank you. Thank you, Mr. Nyamodi.
Most obliged, my lord.
My Lord Chief Justice, on behalf of the third respondent, it's important, my lords, that we put this matter in proper perspective. It is admitted that the response by the third respondent, together with all the replying affidavits, were filed within time. That is admitted. And there can't be any dispute because all this was being done within the glare of the media. We filed much earlier than respondent 1 and 2. The difficulty that arose on that night is that counsel for the petitioner hadn't done what we had done on a Sunday to make himself available for service. And that is pleaded or deponed to in our replying affidavit, that we made every effort to go to counsel's office, Mr. Awele, to go and effect service, and we found his chambers closed. What we all expected is that, as we had done much earlier, a few days earlier, is to make ourselves available for some service. Indeed, when they were serving the petition, we actually came over to his chambers to accept our service. My lords, it's important we don't lose sight of one very important fact, that once we filed the response under your Rule 12, there is no rejoinder by the petitioner. Pleadings are closed. Hence, counsel cannot benefit from my argument to say that there will be prejudice. There can't be prejudice because under the rules, the petitioner is not entitled to a further affidavit to respond to that which we have deponed to. Another thing that, my lords, is important to put in perspective is that this application that we are now arguing before you was served upon us at 4 p.m. today. 4 p.m. today, as we are coming to the Deputy Registrar, is the time that the application was served on us. With a light touch, this shows the zeal and ability of the counsel appearing before you. We are able to respond almost instantaneously. Within minutes, we were able to file a replying affidavit and written submissions. For the simple reason, my lord, that as my Lord Chief Justice indicated, we have a duty to do all that is within our power to expedite this process. This is an application which is a reaction to the 2 motions that the third respondent filed. It is a reaction, my lords, because counsel is also trying to have a go at us, but his having a go at us is on a premise which does not exist under the rules. I would therefore request, my lords, to hold and find that whereas we served the following day, and we served a complete set, there's not a single annexure that was left out. We found a complete set of all the written documents, the DVDs, we served everything upon counsel. My lords, we should not be faulted in any way. My lords, I would request you and urge you to hold and find that the application as a reaction ought to be rejected and to admit the documents as they are and to excuse the inability to serve before midnight on that date because there was no fault on the part of the third respondent or counsel appearing for the third respondent. Unless my lords have any questions, as I indicated, within that time, I have filed and served written submissions and a replying affidavit. Most obliged.
Thank you, Mr. Ngacha.
Thank you.
We'll deliver rulings on all these applications tomorrow.
My Lord Chief Justice, with your kind permission, there was one point I wanted to mention regarding my application, not an argument, it was a request to the court. And I would request your leave. There was a document that was filed late, one of the authorities to the application for joinder as amicus. I have explained this to my colleagues. The copies were availed to the registry and I hope they are with the court. This is an authority from a book on electoral jurisprudence that has been published with the assistance of the judiciary, I believe, and is on the chapter on amicus curiae. I'll therefore be requesting the court, I apologize I was not able to do this earlier, although I'd written an email, to include that as one of the authorities in the submissions of proposed amicus for myself. And lastly, there was also a failure to file substantive amicus brief together with the submissions. And using the same arguments that have been raised by my colleagues before this court, and also the fact that the proposed amicus brief should not duplicate arguments in the submissions of the parties, it was important that we awaited receipt of the submissions of the parties before we could file the amicus brief. So I would request also, on that same basis, that the court allow the amicus brief in the event the court was to admit my application to be filed within 24 hours thereafter on the specific items that have been indicated on the face of the application. That is all, my lords, my ladies.
Mr. Kenyatta, I understand you to be saying that the amicus brief you intend to file will be filed after the court has made a decision as to whether or not to admit you as amicus.
My Lord.
Because
sorry,
the basis upon which the court would make a decision is the amicus brief.
My Lord, if I may respond to that very important question. Yes, the jurisprudence of the court is that parties who seek to be enjoined as amicus, first of all, do not have a right of audience prior to joinder. And secondly, they do not have a right to duplicate submissions that have been filed or will be filed by the parties. My understanding is that the substantive jurisprudence of the court militates against an intended amicus filing the substantive submissions, but they should show through the affidavit or the application their competence and the specific area where they would like to submit on the basis of that competence. So that even though there were some directions requesting for amicus brief, in my application, I made a specific prayer to be allowed to make oral and written submissions after the application for joinder has been had, hopefully with successful outcome. Because otherwise, the amicus brief would not be targeted as required by the jurisprudence of the court. And those submissions were only uploaded on the website today. There is even one set of submissions that are still not been uploaded. And that is why I'm making this very humble request, because I do believe that the submissions of the amicus would assist the court very much beyond the partisan interests of the other parties to bring in the public interest element. That is all.
Lord, could we, now that is in the form of an application, respond in 1 minute? Now that it has been presented as an application.
Just a minute, Mr.
Counsel, Mr. Kanjama.
My Lord.
I'm not preempting your application, and it will be heard on merit subject to what the court says. But because of the nature of this matter and the time factor, don't you think your interest as Nairobi chapter of LSK could be well served by the principal and headquarters of LSK, the national LSK? Otherwise, if every chapter were to come in, it will never end.
My Lord, that's again a very good question, and for purpose of clarification, my application is not made on behalf of any branch of the Law Society.
Are you coming personally?
Yes, I am coming personally.
Not as chairman of the chapter, Nairobi chapter.
I have indicated my various competencies, but the application is clear. Even though I'm in various organizations, it is my personal and professional competence that I seek to assist the court with. And that is why I set out my personal experience and not the experience of any branch or chapter.
Thank you, Mr. Kanjama. We will deal with that tomorrow.
Most obliged.
Yes. Now we come to the petitioner's application for is it access to information? Who is prosecuting it?
Yes, I will, my Lord.
My Lord, can I be heard before my learned friend prosecutes that application? My Lord, on behalf of the third respondents, when that application was filed and certified by the court, an order was made that it be served only on the first respondent. There was no order that it should be served on the third respondent, although we are naturally an important player in relation to the same. So I would like to seek clarification on behalf of the third defendant whether that was just, a slip or a slight oversight, or whether it is a considered decision of the court that the third respondent should not participate in this. Secondly, my lord, that application is premised on a number of affidavits, which are the subject matter of the application argued by my learned friend, Fred Ngatia. So I'm of the considered view that until you make a ruling on whether those affidavits will be struck out or not, I don't think, my lord, it is the right thing for us to argue an application whose substratum is being challenged, or there's an application already that's before the court. So we will appreciate as a third respondent if we could get clarification on those two issues.
Mr. Menasir, don't you have a response to that application?
Yes, my lord, we have a response to that application. Yes, we have.
Filed yesterday?
Yes, we have a response. But we are just seeking whether, is that order, was it a considered view that we should not participate?
You have filed a response?
Yes, my lord, we have filed.
Yes, you will be heard.
We are most obliged.
Thank you.
And the affidavits, my lord?
Mr. Abnasir?
Yes, my lord.
Even in ordinary matters, you can raise a PO and the court tells you that we will deal with the PO in the main application.
I'm guided, my lord.
So we will deal with all those in the main application. Thank you. So who is prosecuting the application for?
I am, my lord. My lord, is there time indication for prosecution of this application?
10 minutes.
10 minutes.
10 minutes.
My lord, then if it's 10 minutes, then I'll try. Now, my lord, this application for access basically to information contained in the servers of the first respondent and logs and transactions to which ordinarily we would have access is premised on the prayers which are found in the petition. My lord, you'd find that the prayers in the petition, the relief sought in the petition, number is found on page 22 of the petition, the paragraph marked E. My lord, you'd find that from paragraphs A to G, the question of scrutiny and the forms used for the transmission of the presidential election results are specifically prayed for. And if you look at the body of the petitions, my lord, in various paragraphs of the petition, the question of the relay and transmission of results is contained in the petition, together with the lack and failure of operational transparency. Those are matters which are specifically brought out as complaints in the petition. My lords, when this court dealt with the first presidential election petition in 2013, the court came to the conclusion that the system of elections in Kenya is a manual system. Basically, that was the decision of this court. Since then, the position has changed by dint of various legislation, particularly the Election Amendment Laws 2016 and the Election Laws Amendment Act of 2017, in which the question of what is the system of elections is in Kenya. And my lord, that question is addressed by Section 44 of the Elections Act as amended by the various legislation or statutes that I've referred to. And it says that, that there is established, that is Section 44, an integrated electronic electoral system that enables various functions which include voter registration, voter identification, and the transmission of results. My lords, in that particular section, subsection 3, requires of the Commission to use such technology that is simple, accurate, verifiable, secure, accountable, and transparent. And that read together with subsection 5, which is the requirement for the Commission to develop regulations. My lord, the importance of technology and the retention of records in the system that is used, the electronic system that is used, and access to the information that is kept in the electronic system in its various functions is underpinned by Section 44. My lord, there was enabling legislation in terms of regulations which were passed, and those are contained in the regulations that relate to technology. My lords, if you look at those regulations, particularly Part 3, which talks about testing, certification, and audit of technology, you will find the centrality of technology, the use of technology in elections, and that is for a purpose. The purpose is contained in Article 81 of the Constitution, which describes and defines the general principles of the electoral system. My lord, in the petitions, some which have come to this court by way of appeals, that system has been elaborated and considered by this court on many occasions. But for the moment, I will deal only with the requirement that in any system of elections that is used, it is required that it must be transparent and administered in an impartial, neutral, efficient, accurate, and accountable manner. That read together with Article 86, my lord, establishes the centrality of information in answering the question of accuracy, transparency, accountability, and credibility of elections. Now, my lord, it would be not quite appropriate for me to quote Joseph Stalin, because we are not a Stalinist state. But Stalin said that those who matter in elections are those who vote, are not those who vote. Those who matter are those who count the votes. The crisis in Kenya has been not about those who vote, but those who count and how they transmit the result of what they are counted in the elections. That has been with us since the year 2002, the question of transmission of results and how those results are transmitted. And therefore, through various legislation where the question as to whether results which are announced or declared at the constituency or the polling stations are provisional or otherwise, that question was put to rest by the legislation that was passed towards the end of last year and this year, that the votes that are counted at the polling stations and announced by the presiding officer, and the collation and tallying of votes and the results thereof as declared at the constituency are final. So the question of transmission of those results to the third tier in the electoral process on election day is an important matter in regard to how those results are transmitted.
So, Mr. Rengo, what are you seeking? Your time is about to...
I'm sorry. So, my Lord, what we are seeking is that the forms, first of all, the forms that were used in the elections, Form 34A and 34B, would, that those should be, the original should be made available to the court. And, my Lord, the easiest way to properly show the court what the problem is, and in our application we have demonstrated, my Lord, that nearly all the papers from 34A and 34B that were delivered to this court by the Electoral Commission were either forgeries or they were forms which in one way or another were not authentic, and they were not the forms that were set out in the law. And for demonstration, my Lord, just I would invite the court to look at the exhibit DNO1 and is Form 34, document number 7. My Lord, if you look at the forms, first of all, they are not the same. There are some in which the names are different. Odinga, Raila Odinga. The security inscriptions which should be on the forms, the anti-copy security features are not there. And if you look at the end of those forms, the part where the total results for each candidate, you find there are some of them there and some are not there. So, my Lord, what we are asking, and the Electoral Commission should not fear this, nor should the third respondent, that we should look into these forms to find out. They should produce the originals because of the security features that were prescribed by the Commission itself and by the law. And finally, that because the electronic apparatus which are there in terms of servers should tell the whole story about the elections. And for those reasons, I beg the court that this application be allowed. Thank you.
Just a minute,
Yes.
a minute, Mr. Orengo, before you sit down. Although your time is up, we can extend a bit of time so that we are able to understand you. You want the entire, is it 40,883 they were? Forms 34A, if my correction is right.
Yes, yes.
Yes. So you want them produced so that?
We want them produced because what the Electoral Commission delivered within 48 hours are not genuine Form 34As.
So what do you want? You want the originals?
We want the original ones so that the return to the elections, looking at those forms, the court would be able to determine whether what has been brought to court were indeed the Form 34As, authentic and with all the security features, and even more importantly, the Form 34Bs that were delivered to the Electoral Commission. And, my Lord, in the application and looking at the affidavits, you'll find what we have disclosed as the problem with these forms that were delivered to court. They are not the authentic forms prescribed under the law, or they do not conform with the first and second respondents' security features, which again we are referred to in the application.
You don't have any particular forms you have flagged out? You want the examination of the entire lot?
We have flagged them all out. Like we have actually done an exposition of all the Form 34B and shown in every respect what's wrong with the forms that were delivered.
So those are the ones you want?
There are 34B, 290 of them.
Yeah.
And the form 34A, 40,833, I think, which are in the custody of the commission. They were able to produce them to court because they had them in their possession. But our case is that what they deposited in court are not the forms that were actually used during the election process.
Yes.
Because examining them, they are not genuine documents, even from the photocopies.
On your own estimation, Mr. Orengo, how long will it take to examine those documents?
For example, for Form 290, my lord, from 34B,
yeah.
If I'm given 30 minutes, I'll be able to tell you.
Okay.
Right from the outset. In fact, my lord, one of the things that the commission did when they gave us their forms, 34B, the one on top had the security features, which when you photocopy it, it shows the reading anti-copying. But the subsequent ones, when they were photocopied, some of them did not have that feature in them, which meant the originals did not have those anti-copying security features. And my lord, I can go on and on from 2090. Even the name of the candidates, there are some forms where the name of Raila Odinga is Raila Amolo Odinga. Some Odinga Raila. Uhuru Kenyatta, sometimes the name is Kenyatta Uhuru. They were used interchangeably. And some you find not only the names, but even the name of the political party. It's an entire mess, my lord. If you could look at these forms, you'd find that this election actually was not conducted in accordance with the rules and the regulations. And my lord, the importance of these forms, they are the instruments by which at the polling station, the decision to declare the person who won or lost at the polling station are contained in those forms.
You've said forms 34A, you will take approximately 30 minutes to examine?
1 hour. 1 hour. 1 hour.
34B, sorry, 34B.
Yes.
34B, you have said you
1 hour. And in fact, if I had assistance, it's an exercise that we have undertaken. If with the assistance.
Now you are moving to 1 hour from 30 minutes.
No, I'm saying, even those 30 minutes will be quite appropriate and enough to expose this fraud, my lord.
Yeah.
And, you know, looking at it even with an empty eye without using the devices for reading these forms, like there are cases where you find...
Under 34A?
34A, that I'll need about 2 hours.
2 hours?
Yeah, so that's 3 hours.
What is the format of examination are you having in mind?
My lord, for example, if I can show this form 34B, my lord, like this one, this is an authentic one. It has the anti-copying feature. It has a barcode. This barcode will show which constituency this particular form related to. There are some, when you use a bar reading device, instead of showing a constituency in Kenya, it shows some place in France, for example, or some institution, which is not the Electoral Commission. Then, my lord, at the bottom, there's supposed to be a record of the names of the candidates and the votes that they received.
Okay.
In many, you do not find that in those forms they have a record of the number of votes found by a candidate.
Okay. Okay, very well. Let's hear the other side.
Mr. Rengo, that is not the only prayer you're seeking.
Yes.
So you've spoken about 34A and 34B.
Yes.
What about the KIMS kit? How much time would you require to do what you want to do with that kit? In terms of your estimation?
My Lord, the KIMS kit, in fact, we were talking to some experts who said that since it is just an access to know what transaction took place on polling day and the transmission of the results.
Because of time, just say 1 hour, 30 minutes, 20 minutes?
A day.
That is 12 hours, 24 hours?
I think more on the side of 18 hours. It will not go beyond 24 hours.
So 18 hours. What about the servers, the login trails of users? How much time would that take you?
I think together it will be those 18 hours.
The entire technological structure and architecture would take...
That 18 hours will be enough.
In your estimation?
Yeah, in our estimation. Because you have to render a decision anyway within the next 4 or 5 days.
What about the saffron identity and security things? Would that be a separate thing or it would be the same?
My Lord, the saffrons were the providers.
But you want access to personnel and their technology. How much time would you require for that? This is important.
My Lord, I would say about 2 days. Yes.
Then the CJ asked you, and you sort of meandered away from it, in terms of the logistics of this, in terms of personnel, is it the court, is it yourselves, is it who?
My Lord, it can be court supervised, but the way we don't want to see the physical servers is only access to that information, which then will be possible without necessarily, bringing the servers in court. So long as we have the access to it, we'll be able to see all those transactions, including what was transmitted and at what time on polling day. We're just talking about essentially what happened on polling day.
So you're asking for printouts?
No, not printouts.
Okay.
Yes, because the printouts now, that will be a manual exhibition of what is contained in the servers.
Yeah.
But once you have access to it, then you'd be able to see what is contained in the server. Restricted to the days which are applicable in terms of this election.
So you actually want to have the servers themselves and look into them, isn't it?
No, not we are talking about access. My Lord, if you look at the regulations, they actually say these are matters which the commission should be able to allow those who want to seek information to have access to. And those are contained in the parts dealing with requests for information and access to source codes.
So you want them opened so that you can be able to access?
Yes.
Okay.
Just one last question. Prayer number 11 of the application. You're seeking time to file further affidavits or supplementary affidavits in regard to this process.
My Lord, the affidavits that we were seeking, which are already part of this application, but we're seeking that those affidavits should be allowed or admitted for purposes of the petition.
The affidavits that Mr. Manzoor contests.
Referring to.
So that
they are properly in place for the application.
Understand now.
Yes.
What about, you've done this access to information. You've received whatever information you're receiving. How does it come back to the court? By way of what?
I didn't get that, my Lord.
You are going to get some information from, if say the orders are granted.
Yes.
You're going to get that information to yourselves. How does that information come back to the court?
My Lord, we come back to court with that information.
How? a report, an affidavit?
We can download the information that is contained in the data storage of the server. We can come back with that information.
Thank you very much.
Yes. Because in the data, even the register, you would get to know what names are there, the voters, and those who voted. All that is in the contained in the data storage system, which is part of the server. My Lord, could I have 2 minutes for Ms. Otiende just to add something I may have?
Mr. Orengo.
Yes.
Please tell us how this exercise is going to be undertaken and by whom.
My Lord, that exercise can be undertaken under the supervision of the court, or it may be by way of the Electoral Commission giving access and giving confirmation whether what we come to court with by way of a report is actually information coming from their systems. Or the court can appoint the registrar together with the parties once that access is given, and that the information that would come after that access is given is brought to the court, a joint report, and if there are any objections or contrary opinion, they can be part of the report. Indeed, in 2013, this court undertook a similar inspection, although that was a manual one, and a report was brought by the registrar to this court. And I think, since technology is central to these elections, this is not an exercise that, my Lord, would take unnecessarily a long time if the elections was a manual election, where all the functions of the elections were manual. Once that access is given, my Lord, it could be even faster than the time frames I've given. I was going to ask for 2 minutes just for Mr. Tinda Molo to deal with the issue of the affidavits, which he had mentioned earlier. But that will be the end of my submission in respect of the prayers. But it will depend on the pleadings we have filed, the notice of motion, and the accompanying affidavits in regard to this application.
Yes, Mr. Amolo.
Thank you, my lords. My lords, in 3 minutes, 2 quick, clear points. Malanet Senior has prosecuted the application, but the particular aspect of electronics is prayer number 4. And what we are saying, my lord, is that the premise of the petition is that their first respondents' servers were unbelievably infiltrated, and a constant of 11% difference between the petitioner and the third respondent maintained from the beginning to the very end for 2.5 days. We have the affidavit of an expert, Dr. Otumba, who says that is an impossibility. It is the belief of the petitioners that an audit of the website and portal, as sought in prayer number 4, will demonstrate the electronic footprints of those who interfered with that process. And that will be important to this court. And that will not be done in court, my lord. It will be done off court by the petitioner's own IT experts under the supervision, if need be, of the chief registrar of the judiciary or other official. And all that this court will get after 20 hours, my lord, is a report on the same. The respondents, the first and second, the third respondent has not shown whether they are interested or not, but if they are, then they could also be present. That is the entire prayer in terms of prayer 4. It is phrased in technical language, But that technical language is contained in the first respondent's own regulations, and it's also an expectation of the law. My Lord, my last minute is on prayer number 7 in terms of the affidavit. My Lord, those affidavits, as you will see, are important affidavits that will help this court establish the truth of the matter. They are affidavits that demonstrate that very point, and it is expected that the audit will confirm those affidavits. My Lord, whether you admit those affidavits or not turns on only one point, my Lord, Article 159 2D, my Lord, which require of you, and I had the honor to sit with Lady Justice Njoki in phrasing this particular part, that justice shall be administered without undue regard to procedural technicalities. My Lord, 4 years ago, this court unfortunately fell short of that article. My Lord, we are inviting this honorable court to breathe life to the express words of that article, as have all the subordinate courts done, and that the affidavits by all the parties, as we said before, be on record, be tested, and the truth be established. That's all, my Lord.
Mr. Molo,
yes, my Lord.
Let me ask you one question. Do you know the time we are left with, the time we have?
My Lord, I fully appreciate the time, and
Yes.
it is limited.
Yes.
Thoroughly limited.
Yes.
Yes, my Lord. Our hope here, my Lord, was that if my Lords were to consider this application, and if you found it fit to grant it tomorrow morning, within the next 24 hours, as my Lords are dealing with other matters, the audit will be going on. And by Monday morning or mid-morning, the report will be with this court.
Thank you.
Thank you, my Lord.
My Lords, Your Ladyship, I would like to respond to this application by addressing two different aspects of the application. One aspect, which is captured in prayer number 5, relates to the forms. You will find prayer number 5 at page 10 of the motion. That is where the petitioner is asking that the first respondent be compelled to give access and to supply to the court and to the petitioners for scrutiny certified copies of the original forms 34As, 34Bs, and 34Cs, prepared at and obtained from the polling stations by presiding officers and used to generate the final tally of the presidential election. Actually, it is 34As that were prepared and signed by the presiding officers at the polling stations. 34B was signed and is the aggregate of 34As at the constituency level by the returning officer at the constituency. So as far as the forms are concerned, I shall be addressing your lordships separately. The rest of the application relates to the ICT, to the systems. And I want to start by addressing that. My Lord, if you look at prayer number 3A, the petitioners are asking that your lordship should order us to give them direct, unfettered access to relevant persons. Those are not specified who they are, the relevant persons. And systems at Safran in order for the forensic information technology experts to fully understand the KIEMS system. Now, to begin with, Saffron were the people, the company in France who supplied this system. So your lordships are being asked to make an order against a party who is not a party to these proceedings or to this application and who is outside this country. I have talked to our experts, and it would take a minimum of 3 weeks to implement or to carry out any of the orders that are being sought with regard to technology. When my learned friend talks about 2 hours, I mean, I don't know. It is not practical. It is not possible. But there is a second reason why the first and second respondents object to these orders that are sought with regard to ICT, which is integrity of the system. They're asking that they should be given access to the system, unfettered access. Who is to guarantee the integrity of the system, of this equipment? This equipment was not just about the just concluded elections. It will be used in future. It costs billions. If you compromise the integrity of the system, you would have to discard it in order to get fresh equipment in order to carry out. It's not practical given the time remaining. And, my lords, remember that the petition was lodged on the 18th. Then the petitioners wait for a week to bring this application. No explanation has been given to this honorable court as to why this application was not filed simultaneously with the application. At least you would have had a little bit more time. And my lord, the petitioner's case is that the system was hacked. In fact, it's in the public domain. At one point, they even gave us the time of hacking, 12:36 a.m. So they have the evidence on the basis of which they made such a grave allegation. Let them present that evidence in the prosecution of their petition. My lord, I think, my lord, Chief Justice participated in writing of a book here. There is a very good write-up, Scrutiny in Electoral Disputes, a Kenyan Judicial Perspective. And at page 261, my Lord the Chief Justice says, scrutiny is not to be granted on ambiguous pleadings intended to enable a petitioner to engage in a fishing expedition and perhaps enlarge his case beyond the scope of his pleadings. My Lord, a petitioner cannot be permitted to state the system has been hacked and then come and make an application in the nature of a fishing expedition. Give us orders to go into their systems to mine data to find out evidence of the hacking. It's for the petitioner to prove his case, my Lord, so that we, my Lord, seek to persuade this honorable court not to have any hesitation whatsoever in rejecting the orders or the orders sought with regard to technology. It is too late. It will take too long. It's not for this court to assist the petitioner to go looking for evidence. And I did not hear the answer to the legitimate, valid question that was posed by my Lord Lenaola. How will you introduce this evidence out of time once you get it? How will you come and introduce it hereby? So we object to that. With regard, my Lord, to the forms which relate to prayer number 5 in the notice of motion. First, when your lordships and your ladyships retire, I invite you to look at paragraph 215 of the affidavit we have filed of Immaculate Concept, paragraph 215, where we set out the 8 security features in these forms, Form 34A, 34B, and 34C. Security features. In other words, it's one or the other. It's either the system was hacked or there was something wrong at the polling station. So that, my Lord, before I say what I want to say, the concession I would like to make in regard to the prayer about these forms, I would like us to be quite clear that Form 34A was completed in hand writing at the polling station. Once the votes were counted, on conclusion of the voting, the votes were counted in the presence of all the agents. And the votes of each presidential candidate was entered in hand in Form 34A. And that, the general rule, was witnessed, countersigned by the agent, it's a security form, and signed by the presiding officer. What am I saying? Is that truly the answer as to whether the system was hacked or not hacked is not to spend the next 2 months here, which we don't have constitution, with their experts saying the system was hacked, our experts demonstrating how the system was not hacked, it could not be hacked. The answer is to look at these forms 34A and 34B, because 34B is the aggregate of 34A. They've asked for it, my Lord. A lot of false propaganda has been spewed out against us. My client, the client I represent, had no favorite candidate in this matter. Its job was to facilitate the sovereign will of the people of Kenya to be exercised in free, fair, transparent elections so that the Kenyan people could elect a leader, president of their choice. That's all. And for that reason, to demonstrate to this court, to the Kenyan people, that their sovereign will was exercised as evidenced by Forms 34A and Form 34B. Provided the examination is going to be supervised by this honorable court, we will make the originals available. They are here in Nairobi. But I ask that both sides, the petitioners and the respondents, should have their agents there, and these court's directions should be quite clear in my submission, namely that we are not to go there and take a lot of time arguing about the forms. The registrar of this honorable court, where a form is disputed, will make a report about that particular form. And I do think that if we did it that way, it will then be manifest as to how the sovereign will of the Kenyan people was exercised and who they elected. In other words, an examination of those forms will show whether the figures appearing in the aggregate of these forms tally with the figures that were announced by the second respondent. That is an exercise that can be completed tomorrow And I do know that this court had suggested that we should begin the hearing tomorrow. When I was consulting with some of my friends, I am a communicant member of the Anglican Church. And a former chancellor of that church. But I do know that there is that passage in the Bible where a donkey, one is permitted to pull out the donkey when it falls into a hole. But the others who feel they would like to go to church. So I was going to suggest, as I sit down, that perhaps if your lordships gave these directions, and that exercise was undertaken tomorrow, from morning through the day, through the night, we can come back here with a report on Monday morning and proceed with the hearing. I would like to ask my friend Issa to make 2 or 3. Sorry, 2. Oh, second response. Oh, it is. It's you who wanted to say that. Oh, okay. Then we'll leave it there. Issa will talk on behalf of the second respondent. Unless there is any question, my Lord, I have taken much less than my learned friends.
My Lords, the application by the petitioners is opposed on several grounds. First, we adopt this. I think it's not the microphone, it might be my height. I can push it. It is on. Yes, my Lords, the application is opposed, and we support the submissions on behalf of the first respondent. But the first point, the chairperson of the Independent Electoral and Boundaries Commission would like the court to appreciate. One of the prayers being sought is for the KIMS devices to be availed to the petitioners. These devices, as required under the election regulations, are kept at the 290 constituency tallying centers. It is impractical for these devices to be secured and transported from all the 290 constituency tallying centers where the returning officers have custody of these devices within the timelines anticipated by the petitioners. That's the first practical reality that has to be considered by the court. But the second one, and more importantly, is what was the role of technology in these elections? It was to transmit results from the polling stations to the constituency tallying center, and from the constituency tallying center to the national tallying center. The results were announced at the 40,883 polling stations spread out throughout the 47 counties. Now, my Lord, if the petitioners are contesting the results declared in particular polling stations, that what was announced is not what was transmitted, there would be a basis for some of the orders being sought here. The petitioners crafted has not identified the polling stations where results were declared and then transmitted through the system, and those results as received were different from what was declared at the polling station. When you identify, it can't be at large. We can't come and ask for the 40,883 from 34As to be, because the transmission system only dealt with transmission. The results are at the polling stations. They are declared in Form 34A. You must first challenge a Form 34A, and when you go back and drill down to the petition, there's paucity of allegations against particular polling stations. Now, the rules about scrutiny and discovery in elections have been settled for a long time in this country. Does this application meet the threshold? It doesn't. It is a fishing expedition that hopefully something will come out of this exercise. Secondly, the commission is being asked to give, and the chairperson is in charge of this commission as the chair, as the titular head. The integrity of the system has been submitted on, but what are the practical implications of allowing outsiders to come into the system? One, the Commission will have to be given adequate time to do backups, because the forensic tools that will be used to access could jeopardize and could make the system collapse. Before that is done, they have to secure all their systems. Can that be done within the strict timelines of this petition? Because then what happens to the integrity of these billions that we have sunk in as a country into the systems for the integrated electoral management system? It has to be secured first. We must do backups by the Commission's own technological experts. Their own consultants will have to come in. We secure each and every bit of these servers, and they just do not handle elections. They handle other aspects for managing and running the Commission. It's just not about electronic transmission of results. This investment has been put in over the last couple of years to ensure that the systems that are run by the Independent Electoral and Boundaries Commission work. In 2 years' time, we'll be doing the boundaries. So this investment has to be secured on behalf of the Kenyan people. If an order was to be met, then the court has to be alive to the fact that the timelines that are anticipated, it's not 2 hours for the backups. No, it's not. And even the forensic tools that will be used, they have to be tested to see if they're compatible with the system. All these are technological hitches that the chairman is alive to and is conscious about. And when you go back to the regulations, there are timelines within which any person would have accessed this information. The first prayer you see in that application is that they need access to stuff from people so that they can understand the KIMS system. Will that be done within the context of an election dispute where the results are being disputed? If somebody wants to understand the KIMS system, that is not for an election petition. That should have been done before votes were cast on the 8th of August. And there is provision in the regulations, the election technology regulations that were passed by Parliament, and there is provision in the Access to Information Act that they had a right to. They would have asked all the questions they wanted to ask about the KIMS and how it was going to be rolled out, and questions were asked and they were answered. This is not the application where now you start going back to rewrite the rules and asking for how the system works. We need to fully understand it, and then hopefully we can get something we can use in this petition. That is not the purpose for this election petition. And lastly, my lords, if we are going to go on the mode of the rules that of the application that have been given, the 4 affidavits that are being relied upon are not part of the record. Because when you look at them, they are titled Affidavit in Support of the Petition. Malala Senior and friend, Mr. Molo Tende, says they are seeking enlargement of time to introduce that evidence outside the stipulated 7 days within which the petition should have been filed. That evidence is inadmissible as a matter of law, because the petition and the supporting evidence go hand in hand. Now, that evidence cannot be introduced by way of an application. You cannot consider it in this application. It's new evidence. In terms of you considering whether or not to grant the orders that are being sought, or even to order scrutiny. Scrutiny is founded on the petition. It's not at large, or on the evidence that is tendered at the hearing of the petition. I understand under Section 82, under the provisions of the Elections Act, the court has a discretion, and even under your own regulations, to order scrutiny. But it must be founded on evidence. What is the evidence that has been tendered in the petition? Not these 4 affidavits that have come in long after the time for filing the petition has ended, for you to consider them in determining whether or not to order scrutiny. So, my lords, if you look at some of the information that is being sought, it's outside the purview and ambit of the petition. What are they challenging? They're challenging the results that were declared. What have the prayers that have been set out here got to do with this petition? In our respectful submission, nothing. It does not address itself to the petition. And for that reason, my lord, we urge you, on behalf of the second respondent, not to allow this application. We have limited time. The timelines that will be required to comply with this rule are not 1 day, not 2 days, at minimum. After the backups and everything is done, at least 3 weeks for the Commission to ensure that at the end of any exercise that will be ordered, they still have the electoral management system intact. That cannot be done as easily as is being presented here in the application. And simply, even if we were to consider getting the KIMS device, because this are part and parcel of the records for all the elections that were held, it will take at least 4 days to get all the 290 constituency returning officers, bringing those devices to the head office, and then they're available to the court. At what point in time will the court be able to first get those devices and then embark on the exercise of agreeing on the parameters upon which these devices, which are expensive, should be used for purposes of assisting this court? In respect for submission, this application ought to have been presented 7 days ago for it to be fully considered on merit. For now, it's an attempt to get new evidence, and that should not be permitted. Unless you have any question on behalf of the chairperson, we urge you not to allow the application.
My Lords, with your kind permission.
Who are you appearing for?
I'm appearing with Mr. Issa for the second respondent.
You know, if you are doing that, look at this, the clock, and share the time accordingly.
Yes, my Lord.
Because you see, if you are going to, he finishes the time and then you start on your own, we are going to run into problems.
My Lord, there was a minute remaining. But
okay, go on.
My Lord, there are only two issues, my Lord, that I wanted to bring to the attention of the court. Based on the submissions, written submissions filed by my learned friends, and I would like my Lords to look at paragraph 5 of the submissions that they have filed, the written submissions. My Lord, the petitioner says, the petitioners contend that the said omission, the same transmission system was in fact not secured as by law required, and in light of the startling discoveries. So they are saying they have made startling discoveries already, have uncovered the petitioners' claim that the first respondent system was tampered with is vindicated. So they already have material showing, according to them, that the system operated by the first respondent has already been tampered with. What is the purpose of the exercise that we are being asked to allow, if they already have the information? That evidence should be tendered, or they should have tendered that evidence for consideration by the court. So that basically what they are doing, my Lord, is saying, we already have the evidence, but we just want to be allowed access to the system. That is one, my Lord. The second one, my Lord, the respondents say that that the results that were procured, they have discovered that the results that were announced were actually not the authentic results. So that they already have the information that, according to them, the evidence, the results that were declared by the second respondent are not authentic. If they already have that information, why is this application being made? And so, my Lord, that is why we are saying that at the end of the day, the exercise that you're being asked to undertake is a fishing expedition. But finally, my Lord, and I think it is important that when you are considering such matters, we take judicial notice of certain aspects. If, my Lord, you are to look at 40,883 return from 34A, it is not humanly possible to look at 40,883 forms within 30 minutes. It's not humanly possible. And so, my Lord, the court should take into account the time that in reality would be required to go through a total of 40,000 forms. Even if you're going to take 2 minutes per form, how much time will that require? And so, my Lord, we do not want to find ourselves in a situation where if these orders are granted, you are now told, my Lord, that the time that has been allocated, 30 minutes or 1 day, is too short, and therefore time is asked, additional time is asked, and yet it is not available. So, my Lord, just to say what my learned friend had said, there was opportunity time for this application to have been made at a time when this exercise could have been carried out with sufficient time available. And what would not want to happen for those who appeared, my Lord, earlier in these proceedings is a situation where now a party is asking to be allowed access to information, and then they will say, the argument will be that if they are given only 1 day and they have not been given sufficient time, evidence has been locked out. Let them produce the evidence they already say they have. That's all, my Lord.
My Lords, mine is a request. At the conclusion of his submissions, Senior Counsel Mr. Muite made what he said is a concession, but which I understood to be a very practical solution. Practical solution because, according to him, numbers will be demonstrated. And we all know elections are won by numbers, not hypotheses. The difficulty that my friend and my colleague, we both have is this. We do not have instructions on what to say to that practical solution. And we would not wish to think on behalf of our client about that concession. It has taken us by surprise, my lords, and it's on that basis that we request you very, very, very humbly, if you'd allow us an opportunity, even 10 minutes, to seek instructions on that concession made by Mr. Muite, because it changes the approach we would have had to this application. And it's a point that was made so forcefully, and it must have some consequences to whatever decision that will be made. Would you please allow us just 10 minutes to seek instructions?
So you would rather we adjourn for 10 minutes?
We are really requesting you,
so
my lords.
You consider that?
Yes, because we will not wish to say anything from the hip. We would rather got instructions and respond to that aspect by Mr. Muite. And you will agree, Mr. Muite is a very honorable gentleman, that he never whispered that point to us at all. Yet
we are independent. Well, there's no reason why I should whisper to him.
We respect his independence, and I'm sure he never whispered to Mr. Orengo as well, no, to Senator Orengo as well. And within the 10 minutes, we'll see how to respond to that point.
My Lord, my Lord, my Lord, I don't know whether it's a strange request, we thought, because this is a matter which is entirely in the custody of a public body. And once that concession was made, I do not think that the instructions being taken on behalf of the third respondent has anything to do with a public duty which is vested on the public body.
We'll give you time to respond to that.
Yes.
because he's a party and is entitled to respond to the application, Mr. Ngatia.
My Lord.
We'll give you 10 minutes. We'll adjourn for 10 minutes. Come back so that you make your submissions and Mr. Rengo wraps up and we move on.
Most obliged, my lords.
Thank you.
Thank you very much.
All rise.
right, welcome back, and Decision 2017 continues right here at the Supreme Court. With me right here on the side, I see the lawyers. We have had to release Kakai Kissinger. He's going to be here with us tomorrow because the court is going to rule on several issues tomorrow, including the admission of interested parties. So I'm still here with Duncan Okach, I'm still here with George, and I'm still here with Moses Kugad. Welcome back, and gentlemen, a lot of things has been said, but one thing that is coming out clearly, if you look at the submissions, first let's get this out of the way. The 10 minutes is for the third interested party, that's the president, right? The third interested party to give instructions to his lawyer, with Fred Ngatia plus a lot of other lawyers there, if at all they want to be part of a request for information as submitted by NASA. So that's why they've taken the 10 minutes. It might take a little longer, but we'll talk about it. So let's get this out of the way. One thing that is coming out clearly from this petition is the issue of time, George.
Yes.
Yes.
Yes, it's true. In two respects. Time is not adequate to prosecute this case. And I think as Parliament gets into details of its work, one of the things that they should look at is what we do with this petition, because we need more time. You can see that there's a lot of struggle as to filing papers, the arguments as to what was filed within time and what was filed out of time. But anyhow, that's the law that we have.
Right.
Because of that, it means we have to do with what we have.
We have. Then my question will be, what was the mischief behind these 14 days, George?
Well, the 14 days was an estimation made, and in fact, the agreement was that because of the fact that in the past days there's been a lot of anxiety for informing the announcement of the presidential election to a swearing in, it was immediately, in fact, after the 2007-2008 elections and when there was a rush to swearing in President Kibaki.
Okay.
That's the time, that's
that
what
was
informed
back in 2007, right?
Yes.
Yes,
that now informed the reforms that we had. And we had a limited time to give someone to continue being in power. I do think that with the experience we have, we probably will look at it differently and probably accommodate it differently.
But is that possible, Moses? Is it possible to look at this time limit? Because it's 14 days from the date the winning candidate is announced, right? But it's turning out not to be sufficient. Looking at the application by Raila's lawyer, James Orengo, in terms of what they require, technicalities, the things they need to go through, already looking at it as a layman, you think there's a lot of time that they require for this?
Yes, indeed, it has become very obvious from what has just transpired a few minutes ago that the time frame set by the law as it is right now is limited and very constricting. But that is what we must live by it. There's nothing much we can do about it. I think the judges will have to ban midnight oil, work long hours. The lawyers will do the same. And coupled with the applications that have just been made right now, you realize that the parties, in my view, the application by the petitioners especially, has an effect of redrawing the petition itself, which I think is contrary to the law. But as it is, it looks like the court will have to make a consideration before they make a decision.
All right.
And it eats into the time that is allowed. And if you look at the time frames that the court had given, the directions in the timelines that they set before the petition was set for hearing, and especially for the pre-trial conference, the timelines that were set are not adequate.
Are not adequate. Duncan, I want you to reflect on this. 30 minutes, this will be determined tomorrow, but we're just looking at general the issue of time. 30 minutes to look at Form 34B, about 18 hours to go through the technology and everything. And you could see the discomfort in one of the judges when he was asking, what is the time you need for this, right?
Yes, Ken, and if you look at those requests, even if the judges were to grant those particular requests, they must actually balance it with the time that is remaining. And that is actually the hardship that they are facing. And I think that is also the reason why Paul Muite, Senior Counsel, has actually given his proposal in terms of doing everything tomorrow and they come back on Monday. But even as I say that, Ken, it is time for us to reflect whether just because of the constraints of time, is that aspect enough in terms of affecting the confidence that the Kenyans will have on the process itself? Remember, it is about leadership for the next 5 years. So if we say that we will just make mistakes or we will affect the confidence of Kenyans in terms of the credibility of that elections just because we had a deficiency of time, it will not actually serve the purposes of this particular proceedings.
All right. Right from the top, very interesting conversation, the interlocutory applications. And what crosses my mind immediately is the fact that a lot of these people want pleadings that were filed out of time. Almost it's cancelling over. If you look at it, right, George? Yes. It's cancelling. They want this out of time, before 11, after 11, you know. It looks as though it's cancelling.
Look, it's very normal. It's very normal and for lawyers to start with the tactical aspect. The tactical and technical aspect is first to look at whether or not you've complied with the rules. So then, if for instance you're supposed to file a case in 3 years, you don't, you're out of time. Whether you have a right or you don't have a right.
How strict is that?
It's very strict. It's actually very strict.
Especially for presidential petitions.
It's very strict because for presidential petition, remember at the time, one thing is the court doesn't reward an indolent person.
Okay.
So you don't sleep on your rights and then claim that you have been prejudiced when you yourself are guilty of sleeping on your rights.
All right.
That's why the law will always presuppose that the indolent will not be aided by the law.
No.
Suffice it to say, therefore, that if a timeline has been put in law, you must meet that timeline.
You must comply.
And you must comply. And if you don't comply, remember, by the way, the law doesn't set timelines against you. It says timelines for everyone. So then, if you're given a timeline and others comply and you don't, for you to be accommodated, it means the others then are prejudiced to the extent that they were not given the same liberty you're given. And liberties must be cross-sectional and equal to everyone. So then, if you do not comply, you must be punished.
You must be punished.
But
if you look at the kind of sanctions they're seeking against non-compliance to the timeline, I think if it was to happen logically, the case will fall.
You see,
yes,
that which is not included is excluded, and that's the law. So then if you don't include something, including it within the timeline set out, you've excluded it.
Okay.
So it means, therefore, the effect of law is excluded. So it follows without saying that either you've done it within time or outside time. If it is outside time, you seek court accommodation. If it's an impossibility, then it's outside time. That's probably where we will be seeing how the court will try to accommodate that. That, in fact, is even more curious because the last time that was accusation against the court when they excluded the affidavit by one
900
Raila Odinga. Yes.
All right. Very interesting. And the response to that, I just want to talk about the response generally with you, George, and then Duncan, you respond.
Good.
It says the fact that you are already assuming that this is part of the petition. That's one of the things that Otiende Amolo submitted on when they talked about the missing pleadings. You presuppose that this is part of it. No, this is actually part of the petition, which we are yet to prosecute.
Now, I'll be very careful because we were warned not to
talk about it. That's why we're talking about it generally, based on what they said. Because Kenyans need to understand what that means.
My understanding is boxing yourself into a corner. This way, you see, already there's an argument as to whether time can be extended to accommodate. Then you confess that it is not part of the petition. Fair enough. Probably it will be part of the applications. But what happens if the applications are either granted or not granted? Does it form part of the petition? And then you want to say, after this is all done, I want to make it part of the petition. You see, you're going cyclic.
That is your understanding, but probably I didn't understand. Let me hear his opinion, then I'll probably tell you what I understood with that.
Thank you very much, Ken. I think I agree with George here that the lawyers for the petitioner, after they had received the responses, they've discovered that certain evidence would have been useful for them. And they have now made an application which is substantially intended to withdraw the petition, in my view, which I think is not correct thing to do. And
that is now these are the applications that they have been talking about. But first talk to us right at the top in terms of the pleadings that were not filed right in time, because that was the substance from the beginning. And then they're saying, you are assuming that this is for this purpose. This is actually for the petition. This is interlocutory. We're just going through the procedure, you know?
The impression created was that the lawyers for the respondents did not understand the pleadings they received from the petitioner, which I don't think is the case. If you listen to what Ngatia said, he made it very clear that there is no way you can now have a dichotomy of the pleadings in a way to suggest that certain other orders can be prayed for when already we're in the middle of the cause of the petition.
Okay.
Yes.
And gentlemen, I know we are walking a very tight rope here with this, right?
Yes,
because it will be ruled upon tomorrow. But Dan.
You know, my take is, the purpose of interlocutory applications are actually to aid the main petition. There are things to be dealt with before you delve into the main petition, such that if there is an interlocutory application, and I will actually delve straight into the application that they have in terms of access. If you've actually made an application to access and you've not been given, and there's a fundamental principle behind in terms of public bodies like IBC, especially IBC at this particular point, they must make themselves accessible. They must actually be open, and that is the fundamental pillar behind transparency. And the reason for that, if that request was made and they actually never acceded to it, you go back to court. In 2013, NASA actually, court as it then was, went to the High Court to seek reliefs, and they were actually granted. But today they have made it in the face of the Supreme Court petition itself. So that once that is granted, it will actually buttress whatever they have filed. But remember, even the Supreme Court on its own motion can actually cause a scrutiny of either whatever was used, if it is the IBC system or even the ballots themselves, and they did it last time. So there's nothing totally wrong with that.
Especially, and the submission by, I think it was James Orengo again, going back to 2013, they requested for some ballot boxes to be opened, and indeed, I remember at the KICC, they were opened.
Yes,
true.
Yeah.
True. You see, there's a dual approach to this by NASA. One is to attack the forms, and therefore to bring out issues as pertaining to the forms. The other issue is technology, and therefore then try to bring arguments that merge the two and bring out the inconsistencies in the two. However, what I think has been responded to is that whether we like it or not, and that's the argument from the opposition to the petition, is that it is purely manual voting system. And therefore, we need to restrict ourselves to what is manual, meaning we need to scrutinize the forms as it were. That's what probably Muite was trying to urge the court to look into.
Okay.
And then